I did. Good morning. Good morning, beautiful humans.
Jeez.
Welcome to day 9 of the Brian Walshe trial.
Loud and perky this morning.
I'm always perky, girl. It looked like they got a little busy a little early this morning, so we're not going to mess around too much this morning. We're going to get right to it. I don't think the trial in earnest has started, but I think they're taking care of some business. We had that very lengthy sidebar yesterday, so I think this may be in relation. There were some issues with some evidence. It sounded like they were talking about, so maybe we'll find out. So I think without further ado, let's jump right in. But before we do that, welcome back. Hey,
I'm wondering where a skier's daughter's from in South Jersey. I went to Atlantic City High.
All right, let's go. Defense case in chief starts today. Let's see what this nonsense is all about. All right, so we do have the bonus of a little bloop bloop, so that's good. Wait, do I have this shit muted? Of course I do. Of course I do. Don't be ridiculous.
You want?
She's got the doily back, babe. She's wearing the doily. She was doily free yesterday. I think you missed my 26th.
In the matter of the Commonwealth versus Brian Walshe, Norfolk indictment 2023-0091, continuation of jury trial.
Discuss this when the
Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walshe.
Morning, Your Honor. Larry.
Where's Mr. Walshe?
Morning. We need the defendant.
Yeah, where's the defendant? Where's his giant head?
Meanwhile,
I'm acting.
Happy anniversary, Jennifer.
Yeah, 26 glorious years. What?
That's
Love that.
amazing.
That is amazing. That is beautiful. That is a testament to love. Congratulations on that. I love that.
Your Honor, for the record, the
Allie and I are
defendant is
hitting
present.
20 this
Thank you,
year.
Madam Clerk.
We were supposed to renew our
renewing
vows.
our vows. That's right. What?
Yeah, well, nothing's happened. It's
Well,
coming up.
well,
Like any day now.
well,
Well,
we'll need some fanfare.
All right, at the close of yesterday's
Interfere with your
day,
Super Bowl
the defense raised with
activities.
me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
we
You
do not.
Oh, I love
Right.
that.
Does that moot every issue that I
Amazing
researched last
spit.
night?
Wait. Shh.
Okay, sorry.
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right.
What?
I will conduct a colloquy with the defendant then now.
Wow, you
And
were
my
right, babe.
intention, is the defense intend to call any other witnesses?
He's not calling him.
We are not.
They're not calling
All
any
right, then,
witnesses.
We'll close tomorrow. We'll do the charge conference immediately.
What?
For the rest of the day. Let me just put in the record.
What the fuck?
So the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously.
I'm
The
dumbfounded.
Commonwealth previously asked this court to exclude the defendant's plea amendment at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously. I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Ana Walshe's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial.
Sure shit did.
And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the 2 lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter.
Sorry, babe. Had to mute you.
And Madam Clerk alerted me to also file this morning 321.
Wow.
Pause.
This is a fucking
Commonwealth
banger.
supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they had no intention, they told us they had no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll
Wow.
hear you at the side of the bench with regard to that.
Pause it.
So now,
What did I miss? She said,
Wow.
I heard she said that they can talk about how they said stuff they didn't deliver. What was the parameters of
She
that?
was, I was tweeting, but like in terms
Wow.
of what yeah, this is breaking news.
I
This is
know, but
fucking
now
breaking
you
news.
didn't pay attention to what I missed.
It-
So
you didn't miss the important stuff. Like there was something else that the state was had filed a motion regarding. They said it was mooted out. So do you want me to bloop back? I mean, we can hear
yeah,
it.
because
We're not going to miss any trial.
as far as I'm concerned, the defense just wrote its own guilty verdict.
They did. Tipton took a huge calculated risk that she was going to have the jury hear that he pled out to those two counts, which are fucking critical
To this
critical
defense.
to their defense. This was a death blow. Man, that is because
Had they not pled guilty, this would be a whole different situation.
you guys see why that's huge, right? Like
I'm
when the
sure they do.
jury's not hearing that he's like taken responsibility for the disposal of the body, they're now left with that evidence being the evidence of the murder.
Right. And had he not pled guilty and that count was still there, then all that would be evidence of the disposal, which he's
Yes.
not fucking charged with in their eyes, as far as
Right?
they know.
They don't know.
It's outrageous. It's
Wow.
outrageous.
Wow. Wow.
What
All
the
right, let me
that-
go
this
back.
is,
So
this is absolutely going to be an ineffective assistance to counsel claim. He should have never wrote those checks if there was a risk that he didn't put on one expert. He told them sudden, unexpected death and didn't call an expert.
do you know who called it? This guy. This fucking guy
Well,
called.
even the judge said from the opening, it was
I mean,
pretty
I
clear-
thought he was going to put on some experts,
Well,
but
me
I
too.
didn't think Walsh was testifying.
Hey,
Like,
even the judge said from the opening, it was clear that they intended to call the defendant. And
yeah,
it sounds like last night they were still or yesterday.
yeah. I mean, look, this is the pressure of a situation in a trial. Like this is an excellent example of how your mind is racing under the pressure of a trial. You know, the state closed. I don't know if I don't know if that took the defense by surprise a little bit. You know, we were hearing 2 weeks, at the beginning of this week. So
The defense must be convinced that they haven't proved intent, but without this other charge, they have, because the jury has no facts in front of it to explain his behavior.
right, exactly. That's it.
Other than you committed a murder and then you did whatever.
Devastating
It
ruling
just
by
turned
the
this into the
judge.
most boring trial I've ever fucking seen.
I mean,
It was interesting before.
it was
Now
gonna
it's
be,
a shit show.
yeah, it's fucking crazy. It's crazy. All right, let's see what I wasn't paying attention for. Let me get. All right, so boop boop. Okay.
No, not that far.
No?
Well, this is about, no, keep going.
Forward?
Like,
Deviation
I want to
from
hear
basic
after she's
issues.
Oh,
Rationale
keep
behind the
going,
holding
right.
applies the equal force. Okay. Possible the verdict.
Which I don't agree with.
We'll just
For
play.
the jury of his prior guilty pleas in this matter. And Madam Clerk,
They stipulated the
we're gonna need
fraud.
to also file this
Federal
morning,
fraud shit.
321. Pause. The Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning.
Just
It's
change your
not
plea.
216, it's
Just
318.
change your plea to guilty now.
All right. On the docket.
Avoid death.
Wait, they're not going for the death penalty here, are they?
Oh, okay.
I don't think so. I don't even know if they have the death penalty. You guys have the
All right,
death penalty?
I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319.
No, they do
I
not.
haven't read it either. It's a motion to prevent the Commonwealth from
No death
basically,
penalty.
I believe an attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they had no intention, they told us they had no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue.
Wow. This is the most ridiculous.
The other
What the fuck are they
motion,
thinking?
320, is I expect the defense will renew after I bring in the jury, ask if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now.
Should I change my mind?
I would.
do
Call a
want
witness for
Let's
God's
take
sake.
it back.
to
It's
defend at this
you know,
point.
in light of your ruling, we're gonna put on a defense.
Right.
You really fucked us, Judge.
Hold on a
What
second,
the
'cause I'm not sure I
fuck are
have
they
my
thinking?
colloquy with me on the bench, despite the fact that I have quite a few
I
binders
would
here.
rule in 2
the
minutes
one I
guilty,
needed was
first degree
done, so
murder.
Yeah.
Stay tuned, nobody move.
They don't even know he was. What a giant
Wow.
mistake by the defense. Had it been a charge
Welcome to Zoom Government.
in front of them, come the fuck on already. Had they not pled
Enter your participant ID. Please enter the meeting code.
What's going on, Judge? You having a hard time with the Zoomers?
had it at least been a charge that the jury had it'd be a discussion back there, right? Well, all this evidence just goes to disposal. All this evidence just goes to disposal. It's not even a discussion now. It's not even a discussion.
I know. It's stunning. It's stunning. It's one of the more stunning things that I've seen in a trial in a long time. Because it completely fucking cut the legs out from the defense. It's like you said, Tipton fucked up. Like
He fucked up by
the fact
entering
that-
the plea. He
Yes.
fucked up in his opening. He's fucking up not calling one expert about sudden, unexpected death to at least give the jury some understanding. Like, okay, wait. So they must be saying that he disposed of the body, but he didn't kill the body. Like something.
Well, the biggest fuck up at this point, aside from, maybe he felt like, him getting the laundry list of, the sudden unexpected death possibilities from the state's witness
Right.
was sufficient. What he did not in any way, shape, or form account for is the fact that these fucking pleas were not coming in. He had to put his guy on. It's the only way it was getting in at this point. He couldn't take the risk on relying on the judge to allow those to come in without the defendant testifying. And he did, and he fucked up. It's exactly like you said, man. It's like this jury has no clue. We want to make this clear to you guys. This jury has no clue that this guy was charged with the lying to the cops and the illegal disposal of the body. None. So now, this jury who's been sitting here hearing all of this evidence,
Horrific.
watching
Horrific
all of this evidence of him at Lowe's and Home Depot and all the fucking places he's
And all the
walking around
searches.
humming Psycho Killer under his fucking mask, now all relates to murder.
I mean,
It's
in the
the only
closing,
thing it can in
in
their
the closing,
minds.
he can talk about how you heard that the searches are how to dispose of a body. You heard about, you know what I mean?
Can
Like,
he?
yeah, there was a search how to dispose of a body after a murder.
But it has no impact.
Right, but it's also after a murder.
The jury's gonna be like, okay, so like, why are you telling us about like he was trying to figure out how to get rid of the wife he just murdered? You know what I mean? Without them knowing that that was a charge that he's pled to and accepted responsibility for, that has zero impact on a jury. They'll be like, why is this? Yeah, obviously he cut her up and probably put her in those fucking buckets. Like, and you
Yeah,
know
I think what you're
mean?
saying, I think you're right that they're relying on what they got out with the ME.
Yeah, for sure. And that they didn't prove intent. But this jury, the missing part for Tipton, the thing he keeps forgetting is that she's clearly been cut up. They proved that. They proved it. Her DNA was on the hacksaw. Her DNA was all over everything. She was killed. He was the only person there, aside from mom. And now they have no idea that this guy pled out to anything else. They have no idea of that concept. He can't argue it. He cannot argue it because he didn't put any evidence on. He can't. I don't know. What is he going to do in closing?
He can argue that the evidence that there was, you heard about sudden unexpected death from their own ME. It can happen with a perfectly healthy person.
Mm-hmm.
He was searching about how to dispose of a body again after a murder. So I don't know how that works for him.
She is going to have a very, very tight leash on that, babe. She's not going to allow him to get into that argument. You know who else is like stunned that they're not putting on a defense and he's not testifying? The judge.
Yeah.
Yeah.
Especially after that opening.
It's fucking crazy.
And the jury is going to want to convict this man of something. They should have never pled guilty.
Thank you, Judge.
Mr. Walsh, if you could stand and raise your right hand, please.
He-
Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing to be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Wow.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions.
Wow.
Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Including the promises
Yes, they
made in
have.
opening.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Wow.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision.
Wow. She's like, good.
We can bring
You did
the jury.
exactly what you deserve, motherfucker.
So they're not going to even go to closings? They're just going to let the jury go?
I don't know if, I mean, the state was aware, theoretically, like they had this discussion yesterday, clearly.
Oh, she said that as of their discussion yesterday, he was going to testify. They had her going over all of this shit, and now it's all moot as of this morning.
Wow. Wow. They're regretting it. I can see it in their faces.
What they're regretting
Second
is having
chair's
pled
pissed.
guilty in the first place.
Second chair's pissed. What a turn of events. What a turn of events here.
This whole trial's become worthless to watch.
Nah, fuck that.
I mean,
Don't be ridiculous.
big turd now.
This is jurisprudence in action. This is a fucking amazing learning experience for everybody. This is incredible.
Well, motions and CPA
This
said
would
a
have meant
Norfolk.
nothing. Watching this would have meant nothing if we didn't watch the trial.
Motions and CPA says a Norfolk jury found another man guilty of involuntary manslaughter this year in Gulf Turk versus Red Rum. He strangled her, admitted it, and they found her body. So who knows what will happen?
I feel pretty secure what's going to happen here. This is going to be a quick verdict. The
Yeah.
jury has no other way to think of the evidence that was presented to them other than it was evidence of the murder.
Jurors entering.
Well, we'll see what they do at closing, but without another charge to hang their hats on, they're not wanting to walk out of this trial without finding him guilty. So that was the biggest fuck up. A risk should have never been taken.
Hear ye, hear ye, hear ye. All persons have anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court. For your attention, you may be heard. Those here to call from Massachusetts in this honorable court, please be seated. Please turn off your cell phones.
Unreal.
Insane.
Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case? Yes. Were you able to comply with my order that you?
If you have come in late, if you're a late arriver and you're like, what in the fuck is happening right now? Why are Bob and Allison freaking out? Why is everybody stunned in the chat? We learned bright and early before court was even supposed to start that the defense has rested. They are not putting any witnesses on. Brian Walshe is not testifying. They are done. All that is left to be done now, as far as this trial is concerned, are closing arguments and jury deliberations. That is it. There is no rebuttal case because the defense did not put on a case. It's stunning. I'm blown away. I am like absolutely shocked. I'm like beyond shocked that this is the approach. The other significant thing, if you're really late getting in, the judge ruled that she will not be informing the jury. And this is a huge win for the Commonwealth, that she will not be informing the jury that Brian Walshe had pled guilty to the 2 charges of lying to the cops and the illegal disposal of the body. That means that all of the evidence that the Commonwealth put on in their case in chief in the minds of the jury only relates to one thing and one thing alone, and that's that Brian Walshe killed his wife. That's it. They don't have anything else to lean on.
Here's the thing I was going to say. In retrospect, right, what they could have done if they wanted Brian to seem honest and wanted the jury to know he accepts responsibility for what he does, and they, at the time, must have been convinced he was going to testify, is that they could have let him just admit that on the stand. You know, he could have said, I don't deny, disposing of the body. They could have said it in the opening, even though he wasn't taking the stand. He doesn't deny, but now that it's not in front of them, oh gosh.
This is a 10-minute verdict.
I do consider it throwing in the towel, but I don't think they do. I think, like you said, they think the Emmy put enough in about sudden unexpected death. I don't know why they wouldn't have at least.
And they didn't meet their burden.
Experts.
He doesn't believe, Tipton, with every fiber of his being, does not believe that the Commonwealth proved beyond a reasonable doubt that Brian Walshe killed his wife. The problem with that analysis is the fact that now she has removed the possibility that he just disposed of the body and that she hadn't died, or that she died unexpectedly without his.
Well, no, it's there. Like you said, it's there from the ME. They got it in.
But she is going to limit the fuck out of him.
I don't think so.
All right,
they can make reasonable inferences from the evidence.
Bet.
They can make reasonable inferences from the evidence. Would include all this evidence only speaks to the fact that he disposed of the body. That's what this evidence tells you. It does not tell you how she came to die.
She's going to limit him. I'll bet you. She'll let him talk about the unexpected death shit, because that came into evidence.
It's a reasonable inference from the evidence. It is a reasonable inference from the evidence.
You know what a reasonable inference from the evidence is? That he murdered his wife and disposed of her. That's a reasonable inference. Sorry, I disagree, madam.
No,
All right,
doing
let's go.
research about the case.
Yes.
Well, it's a
You
short
comply
day.
with my order that you not go on any social media or access any news media. Yes. And you still all have open minds. Yes.
Well,
With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests.
Defense rests.
Wow. Crazy.
I'll see counsel at the side of the bench.
I wish I could see the jurors' faces. Is there somebody
Yeah.
tweeting?
No,
Is there a
I
media person?
I haven't seen anybody like live tweeting this trial, like that's sitting in the gallery at all. Maybe I'm missing it. I don't know. I haven't seen one person, which is odd. All right, we got some blooping. So yeah, she did say closings tomorrow, right?
Barr says, wait, if the jury doesn't know he
Jurors,
disposed.
I think I've referred to the trial as, I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really 2 things that happens interspersed. I'll explain. And 2 things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning.
Wow.
I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here. The charge that the crime that is charged here, excuse me, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So
Get your
those
text,
2
babe.
parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers of what they're seeking. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today
Just
is
relax.
getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise to the court, please.
Wow.
Jurors, close your notebooks and follow me.
Wow.
So Boris says, wait, if the jury doesn't know he disposed of the body, he might get away with this. Well, the jury knows he disposed of the body because they saw the evidence.
Right.
There's no question that he disposed of the body. The issue is they want to find him guilty of something. They just sat through this horrific trial of this horrible man.
I don't see any other thing that they can walk away with other than he killed his wife. Like, they don't even, like, you guys remember, they don't even necessarily know unless they were following the case prior to. He was charged with disposing of the body. That doesn't even exist as an option in their brains. For them, this is a one-charge case, murder. And they provided evidence that he went and bought all the shit up.
A couple of
As they're
housekeeping
concerned,
things.
They could actually think that the way that he murdered her was by dismembering her. I mean, that could be in their minds. That's how he killed her. There is no other option in their brains based on the evidence they were presented.
And the judge is going to remind them the openings were not evidence and the closings were not evidence. You got to base your verdict on the evidence.
Yeah. I mean, that's a instruction. She is going to tell them that. She will reinforce that. To me, this thing is going to be a very, very quick verdict.
I don't know. I mean, as I sit here and think about it, I don't know.
Based on the evidence and based on the ruling that the judge is not going. And again, if you guys came in late, like after I just did the little thing a few minutes ago, really the most significant thing that happened beyond the defense resting without putting on a case, which they don't have to, you know.
But they promised the jury they would in opening.
They promised the judge was under the impression Walsh was going to testify. Allie was like, he has to testify. I mean, how else are they proving up the shit that Tipton, discussed in opening? And she's right, but ultimately the way that I felt when they closed yesterday, but again, I was relying on the fact that they were going to hear that he had pleaded out to the disposal charge. Because without that piece, without that critical piece, they have nothing in terms of the defense. Like, you needed that, because then the jury's like, okay, all right, so they were, now it makes sense why he kept asking all those questions about the unexpected death of the Commonwealth's forensic pathologist or whatever he was, the ME. And that clearly, and he's going to be able to argue that, to some extent, because if she would have read into what he had pled to, I think that he would have been given more leeway to argue. I think he's going to be limited, babe. I really do. I think in terms of that.
I think that their biggest problem is if they're going to say, like, the evidence suggests this, the searches suggest this, the search says how to dispose of a body after a murder. So that's it. That's it.
I don't think the judge is pissed.
I
think she's stunned like the rest of us. Like, the judge is thrilled. She's getting this case off her docket.
Done. Right.
Yeah,
Clear.
she's not pissed.
She might take a vacation.
She's like, oh shit, I got a full week that is nothing on my docket. Free week next week. So
she seems like the type that'll fill in her docket.
She does.
Let some lawyers know I freed up. I want you in here for this. I want you in here for that. But
wow, blows my mind. Mind-blowing turn of events. So, but at any rate, to finish my point, she ruled that the jury's not hearing what he pled to prior to them being impaneled. So that they're going to have no knowledge that he pled guilty to those two things. So,
and that he's getting penalized, forced to take responsibility for anything that he has done, which is going to make them more inclined to find him guilty.
This is going to be, I'll be shocked again if this is not our verdict. It's like, you got to get back there, but like, there's one count. It's a pretty simple count. It's not, this isn't the Karen Reed jury instructions.
Something together in closing. We're gonna have to see.
Yeah, I don't think so, dude.
They should have done the fucking research.
If I could get tipped in on the live right now, I'd be like, yo, that ruling, bro. That hurt, huh? It's like, if you had your druthers, would you decide to put him on at least put him on, even if you're not going to put on the doctors?
Again, in retrospect, he could have just not had him pled, but still said an opening. He doesn't deny disposing of the body. He doesn't deny lying to the police, but the evidence isn't going to show.
Doesn't he still at that point, like, if he says that,
you would still expect him to be called, but he did the same thing anyway. He made promises. He got up, he checked his email. He made promises.
See, Amy, the problem is I don't think that they proved intent either, but that was relying on the concept that the jury was going to hear about the fact that he pled to the disposal of the body. because that fits very neatly, aside from the one Google search that Allison pointed out where, after a murder, that one is pretty painful for the defense to kind of contend with. But without them knowing that, now you're sitting here with a jury that all they've heard was this evidence of him, going and buying all this shit that clearly
They want to find him guilty of
disposing her
something.
body. They're left with no other explanation of what happened to her other than Tipton asking a bunch of questions. Isn't it possible that people can die in this way and that way? And is it unheard of or impossible for a young, healthy person to die like that? You can't rely on that alone in a case like this.
I just wonder if they
there was
ever
nobody.
intended.
Did we even hear if his mother was in that house? I think was she living there?
No, there was he was supposed to have her after surgery, but it sounded like he sent her home early. I don't know.
There's no other.
Let's see if they're doing even the charging this afternoon or what's going to happen. Then we can keep discussing.
Yesterday at the side of the bench, we had a discussion about, during Mr. Mootlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that
I
transcript.
want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Sorry, I had a bad night's sleep. I keep yawning. Shocking.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I'd considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt motion.
No, when they closed yesterday, I didn't think they were going to put them on. I like Allie was like, what? They're definitely gonna I did not think they were going to call them. I think, but again, my thinking in terms of the way that I was thinking was based on the fact that I believed that the jury was going to hear about the 2 counts that he pled to. Without that happening, to me, probably the most powerful evidence, low key, is the fact that I can't remember if it was the last witness or second to last witness, whoever testified about
Her not loving him anymore, loving him less.
But even more important than that was that the phone that was allegedly missing was being charged.
Oh,
and accessed.
They mentioned that in their.
Who brought that up?
The state mentioned it in response to the motion for directed verdict, and I think it came into evidence during the trial, but got, to me, lost in the shuffle of everything. Plus, I'm still recovering, so there was some days where I just passed out in the middle.
Yeah, I can't remember where that came in, but to me, that is going to, I'm sure the Commonwealth is going to hammer that point.
Oh yeah, that's a big
it's like
point for them.
Yeah, it's a big point. All right. So what we're going to do now, they're going to go through the jury instructions. They're going to bicker a bit about what instructions should be read, what shouldn't. There should be any changes to the instructions in terms of the wording.
Evidence and bad acts. I had that, I considered that as I was drafting the draft instructions yesterday. And I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions. And I made a mental note to go back to those this morning, but I didn't frankly have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
I wonder if
So-
the defense ever planned to call an expert.
Said more bluntly, if there's
Yeah, I
something.
mean, they had to disclose.
I know, but I
Right.
wonder, I think going back to the opening, like you're going to hear from Dr. blah, blah, blah. You know, they would have said a name.
Well, I mean, they supplied names to the Commonwealth.
What I'm saying, how do you know? Was it on? Oh, we had the defense's witness list.
Well, they put, when Tracy sent us the Commonwealth's list, they included the prospective list, which I'm assuming was coming from the defense. I think Allie keeps yawning.
I do.
Yeah, but Joe, to answer your question, Joe had asked, can you estimate how many hours the defense team wasted preparing? You can't look at it like that, Joe. Like
But a ton.
a ton, hundreds of hours, but you always prepare as if you're going to trial. I mean, unless you have a case where you know pretty early on through conversations with your client after discovery that you're going to be pleading the thing out in that limited type of circumstance, you know, maybe you're not prepping for the defense, but if there's a shot that you're going to trial, you have to prepare as if.
I'm thinking if they did have actual experts lined up to call, I'm thinking they discussed the statement, right, of not presenting a defense. And that's why they decided not to even call, since he wasn't going to testify, to not
flesh
even
that out of like what. So wait, say that again.
Well, assuming like that they had an expert lined up that was going to testify, and then they've decided he's not going to testify, that I'm thinking that they were focused on the statement it makes to the jury to put on zero defense.
Yeah.
And
Yeah,
that's
I
why
agree.
they would have decided to not call an expert that they were otherwise going to call, given they asked all those questions of the ME. I kind of forgot about that until you said it. So it still gives them sudden unexplained death.
Yeah, and it does make a statement when you don't put on a defense. And Tipton will hammer this point home, you know, that the burden is on the state, and we have no obligation whatsoever to put on any defense. He's going to hammer home the fact that he, in his estimation, does not believe that the state proved to you, the jury, that Brian Walshe killed his wife.
I can't imagine. Sorry, babe. Sorry.
No, that was it.
I can't imagine. So in the beginning, the other thing that was mentioned was Tipton said, yeah, the prosecution doesn't plan on talking about how we wrote checks that we didn't cash. And the judge is like, well, they're allowed to do certain things. I'd be shocked. I mean, it would just be ridiculous for the prosecution to not say. You have to ask yourself, why did they tell you things that they didn't, prove? It's just,
I mean,
like you said, it walks the line of
it does,
not
but
calling the defendant.
think of Karen, her in season 2. I mean, Alan wrote a lot of checks in his opening. You know, walking out of that opening as observers of that trial, I was fully expecting that they were gonna dig into the people in that house again.
Sorry, I
You
gotta
know,
stretch
he
my arm
made
out.
he made a lot of representations in that opening that they were going to hear from and about people in that house that went far beyond just what they ended up hearing. So, I mean, it happens, but it is a statement when the defense is like, you know what? Because it's like what I was saying when the defense, when the Commonwealth rested yesterday. I'm like, man, Like they didn't prove intent here. They didn't prove malice forethought. They didn't prove it. That's the way I felt. I
home.
tweeted it yesterday. I'm like, they
Maybe
didn't prove it.
Maybe they went home and watched all the law tubers and was like, wow, sounds like the public doesn't think we've proven intent, but the public knows he pled guilty to disposing of the body.
That's the thing. That's the key piece here. That ruling that she made this morning destroyed everything for the defense. That entire concept. Had she come out and said, you know what? Yeah, I'm gonna advise the jury. We're gonna, I want you guys to work out a stipulation that he had pled to these two things. It changes my view of whether or not this was an insanely bad move.
But I do think she hinted to the fact that she wasn't going to let it in unless he testified. We kind of talked about that early on. Like if he testified, it was sure getting in. But
100%.
If it didn't, she might not let it, even though I do think there is relevance to it. And I don't think it implicates all the things she said about the jury considering extraneous evidence, about them or information, about them contemplating the possible sentence of those charges. Like, I just don't think that that's an issue. You don't need to say he pled and this is what the sentence is going to carry.
Right.
Especially
if they haven't really even done. Well, she does it. It's none of the jury's business as to what he's getting sentenced to, because that they can't take that into consideration anyway.
Right. But the biggest thing to me is that I think they're going to want to find him guilty of something. They're going to want to know that he suffered a consequence for dismembering and disposing of his wife's body. And when they're left with just one charge, it's going to be really hard for everyone to be like, yeah, let's just let the guy walk out of here.
That
in their minds is what they're thinking happens.
I mean, and they're going to think that he killed his wife. It's that simple. Like you keep presupposing that they're going to be thinking about this as a disposal case at all, and they're not. I mean, Tipton can argue it, but for a normal person, all that is going to appear to them to be is that he killed his wife and then chopped her up and got rid of her. That's all the normal person's going to think. You know what I mean? Like, nobody's going to be sitting there thinking, well, it's just like they don't have any other thought in their mind of him even being charged with anything else. For them, this is just straight up murder case. And she was there 1 minute, the next minute she's gone. This guy went out to all these different stores buying all the murder kit shit. He's Googling all this weird shit. I mean, they're only coming to one conclusion, that he killed his wife. All right, I will fall off my ball. If they come back with the not guilty, I don't know what I'll do. I will be beyond stunned. I will be like,
let's see what they put together at closing.
Yeah, we'll see. We'll have to wait for tomorrow. So closings are going to happen tomorrow.
Yeah.
By the way.
And that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction, potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right.
Because
I will take a brief break before we, and what I am going to intend is this. The draft instructions as I have them right now includes.
Huh?
To me, that's the problem. The consciousness of guilt instruction. And that's why that this evidence that they're saying is consciousness of guilt of murder becomes relevant. It's consciousness. It's consciousness of, it's not consciousness of guilt. It's the act of disposing.
Yeah, but you're right. That is a huge instruction. Do you guys see why Ali's saying that? Again, if the disposal thing,
the lying to the cop and the disposal are both consciousness of guilt at this point.
Yeah, 100%. But without the jury knowing about either of those things, now it just looks like he was trying to
cover up the murder.
Cover up the murder, man. It's it. So that instruction is huge. Huge.
But I think for that reason, it's relevant that he was charged with and pled out to, I don't know.
I mean, she's up and made her decision on that shit.
Yeah.
They ain't hearing it.
What I tried to do is, when I was scratching my head, saying to myself,
So
why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now and this is in part 2 of the instructions.
she is such a good, this is exactly what it would be like if Allison was a judge. Like, I'm serious. Like, this is the kind of shit, like, her just saying that, like,
Right.
puts her head and shoulders above other judges that you'll hear on the bench. It's like that kind. It's like she was saying exactly what Allison was just saying from the bench. Like, I'm sitting at, like, she's talking to the defense. Because apparently the defense wanted this shit in.
No. She's talking now to the defense about, she's saying any instruction that she's scratching her head wondering why they put in, she has put in italicized. And she gave the example of the defense wanting to put in the object of the murder must be a human being, which, as we all know, is part of like the old school language. Like, I'm looking at the like the present.
Yeah, we read through it.
Right, and it doesn't say
in there.
Right, of a human being, but that used to be what it said all the time. So this could be, lawyers get in the habit of using this is what I use for my jury instructions. This is, so the person being a human being is an element of the offense. And she's like, all right, why do you guys want that in? Because we know the person at issue is a human being.
Was she talking about the instruction in general or just that language?
I think
like,
that,
why wouldn't the state want that in? Well, of course they want that in.
No, I think she's just saying, why do we need to clarify that it needs to be a human being when we're obviously dealing with a human being?
Yeah,
there's no question here.
I thought she was talking more broadly about the consciousness of guilt. Maybe I'm wrong, though.
Go back. She was talking about all of it, but then she gave that little example.
I'll just go back a little bit. Okay.
Tend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics.
So she's speaking,
so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now and this is in part 2 of the instructions. Impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics.
Prior bad act would be disposing of the body.
Who's closing for the defense?
I am.
And who's
Narcissist.
closing for the Commonwealth?
Who did the opening for the prosecution? The male?
Yeah, I think so. Tipton did the opening.
I know. Hence the narcissist comment.
Yeah. Misogynist.
No, just that he needed to do the whole, he had to control everything and do all the, only I can do it perfectly. I will not let second chair do the opening. But I'll let her speak on all the issues that matter.
The address of the refuse center, 300 Forest Street, Peabody.
Yes, Your Honor.
Peabody?
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it.
Clearly.
Yeah.
And that town is spelled Peabody, but clearly they call it Peabody.
Puberty.
Commonwealth seeking a mode of instruction.
Mm.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and
Up.
see if there's some other language you would prefer
Hey,
that
pause it a
adequately
sec.
captures trial evidence.
Pause it a sec, babe. So the motive instruction says the Commonwealth is not required to prove motive as an element of the offense. However, you may consider an absence of motive evidence in determining whether the Commonwealth has proved all the elements of a crime beyond a reasonable doubt. Unless there's another motive instruction, that's the one that I'm seeing.
Yeah, I mean that kind of cuts both ways for the Commonwealth, but
It's
mean,
something
they-
the defense would want, for
Yeah.
sure.
for sure.
All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27.
And she's talking about the model criminal jury instructions as opposed to.
Yeah, some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So-
it should have been.
So
Don't
just
waste
take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes.
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those. I
opening?
will get you those. There
See
are
that, Tipton?
parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law.
Hadn't
I'll
looked
get it
at
to
it for
you.
a while because
Thank you, Your Honor.
lawyers usually take great care to not write checks that they can't cash at trial.
Yeah. Wow. Stunning. Stunning.
Ah,
Let's see. Let's go through some supers real quick, see if we have any
I wish I could
questions.
drive. I'd go get us some coffee.
I'll go get us some coffee.
You want me to talk through the.
So yeah, you
So
do
here's
that.
the
I'll go get
question.
us some coffee. Hold on. Let me just do this one because it's a Venmo and it's a good question. Let me see.
And then while you're looking for that, the question is, are we just going to stay here and chat? Do we have
Yeah.
anybody who won that wants to come on for 10 minutes now?
What do you mean? Yesterday's winner was who won yesterday?
I'm
It
sure.
was
Presumably
wait,
that person knows. I
that
saw a
person-
screenshot on
I
your-
took a screen grab of it.
Yeah.
Oh, it was Ashley. Ashley. Well, I'm gonna run it here. Let me just read this real quick, this Venmo, so we can address this question. Let me see here. Okay, so Danielle, thank you first and foremost for your $5 Venmo. And she asked, was there a way the defense could have known the judge wasn't going to allow that he pled to and made a decision to rest or not based on that?
Yes, they could have researched the issue thoroughly to figure out if they were on like no question asked footing on that issue, and presumably pushed the judge for its pretrial ruling sooner, indicating our defense is highly based on this issue.
That's exactly, that's it right there.
But before I allowed him to plead, I would have researched and made sure it wasn't a gray issue at all. It's black and it's white. And if it's not, don't plead.
Right.
So absolutely positively. And that's where I'm thinking there could be because
Ineffective.
even when something is based on strategy, it makes an ineffective claim very hard. However, if that strategy was based on a misconception of the law, a mistake of fact, a mistake of law, something like that, then it doesn't become strategy at all, and you can challenge it.
Right. Yeah. I mean, it was, man.
But it's you don't make a decision like that without researching the law first and knowing it's black and it's white. Because if it's gray, we can't risk it.
Right. That's what you're telling your client,
Right.
because you're strategizing, amongst yourselves as the attorneys, but you're clearly, in terms of strategy, that's not left to the defendant, our clients. That's left to us. But notwithstanding that, when you're discussing the possibility of whether or not they're going to testify and you're trying to work through that problem, you have to take into consideration all the things that Allie was just talking about, because, like a lot of times, I'd say a majority of the time, I feel comfortable saying that we're waiting until the state's rested before we decide how we're going to advise our client, whether or not we think. And I'm taking narcissistic fucking Murdoch type fucks out of the mix, who are, there's nothing that you can do. They're testifying because they think that they're the smartest person in the world. I'm taking them out of the equation. I'm just talking about normal people, like normal people where, you're advising them and they typically will take their advice from their attorney because the attorney knows better in terms of how the process works. And they'll typically do what the attorney says they should do, but ultimately with it being their decision. But you're taking all that into consideration. And like Allie's saying, if there was even a distinct, if there was a remote possibility that they weren't going to be able to get those heard by the jury, and I'm talking about the fact that he had pled out to both those things, you can't, I mean, to me, that's where the ineffective assistance claim comes in on the front end. This should have been handled. It's like whatever.
I don't know that it would carry the day, really, at the end of the day, because it's a very high standard. And you also have to take into effect that, all the evidence is so, the evidence against them. And they're going to say it's compelling. So maybe they call it harmless error. I don't know. Writing checks you can't keep. That's pretty big.
Yeah. Yeah, it's a thing. But like I was saying, I don't know if you heard, I mean, in Reed, Jackson definitely
I know.
wrote a lot of checks that he didn't cash in trial.
But
too.
luckily they didn't have to worry about an appeal.
Right. All
right, go live.
I'm gonna make my coffee here because I bought all the goods.
Oh.
But I'll go get yours.
No, it's all right. I'm fine. Are you live though?
I'm about to get live because it's probably going to be pretty close to when we're coming back. What time did she say? 10:30?
Yeah. So we only have 10 minutes then.
Yeah. All right. So just text me what you want. And I'll
No, don't worry about it. They're going to be back in 10 minutes.
Well, I'll make you coffee then.
Yeah, just make me coffee.
All right.
All right. So let's go through some of your other stickers here. Supers. All right, Boris, thank you. I'm assuming by now you understand what happened. And we put this up from Beagle Rescue Mom. Oh, wow. So now the jury won't know he pled guilty to dispose of the body. Larry said in opening, quote, Brian Walshe will tell you. This is cray-cray. Yep. Unsolved Amy Boston, thank you. And I did address this. Why do you think they're throwing in the towel like this? It like almost definitely feels like that, but I think they think that, like Bob said, they're convinced that the state hasn't proved its case. Boris said, and we talked about this one too. Wait, if the jury doesn't know he disposed of a body, he might get away with this. Again, the one thing that they proved beyond any shadow of a doubt to me in this trial alone is that he disposed of a body. Jess, do you think maybe Brian indicated he would testify and then got cold feet? Now it's time to put up or shut up. I think, and this is just my opinion, obviously, his lawyer said, we don't need you to, and it can only do more harm. And it's definitely a huge risk putting this guy on the stand. He's going to be questioned about, so you were chopping up your wife's bloody body. Where were the kids? Was it in her bed? Where is the body? What did you do with it afterwards? I mean, he would have been exposed to a lot, and all of his emotions on the stand, asking those questions, answering those questions. I mean, it would have been really bad, really bad. There's no good that comes from him testifying except to get in the fact that he's admitted that he did these things, that he disposed of the body. And I don't know if he would have changed his plea mid-trial to those. I wonder if it would have been told to the jury. But I still think that in opening and in questioning, they could have addressed this. They could have left both charges there and then done what I had been saying all along with every witness. So all of this blood evidence, it is consistent with someone who, with acts involved in the procedure leading up to disposing of the body, but doesn't tell you how she came to die. All those questions. So I don't think it was that he got cold feet. I think that his lawyers suggested he not take the stand. That's what I think happened. Oh, voluntary. Whoops. Typo in the last. Motions and CPA said. Where was motions? Oh, right. Okay. So it was voluntary manslaughter. Thank you. Motions and CPA. Christy says, how rare is a defense does not call what that happens all the time. Happens all the time. And it used to happen a lot more. Like, I think in more recent years, like younger lawyers are like, we got to put on a defense. Like this whole, they didn't meet their burden, reasonable doubt defense where we do nothing. It doesn't work for us, but that happens all the time. KM Zencat says, is Brian done with his federal case? Does he remain behind bars even if the jury acquits tomorrow? Wild. I thought they said his sentence was, I already forget, but the I understand what you're saying. Like, does he still have time? Like, if they were to acquit, would he just get out? And I don't know the answer. We could go back and look at what they said in that very last stipulation, because it gave us like when he pled, and I'm not sure if it gave us how much time he got or not. Keep an eye in the chat because I'm over here looking at your supers, but I'll pop over there in a second because we got the last one. Captain Rhett Snuggler, adore how you love your wife, Bob. Oh, we'll put that one back up when he comes back. All right. Well, now Cody says, can Tipton in closing say something like he pled guilty to disposing of the body? Absolutely not. Absolutely not. That he cannot say. And that's all the evidence proves, since closing isn't evidence. No, that he cannot do. But I think, although Bob thinks there's going to be some parameters, I think he can absolutely argue that all this evidence shows is that he disposed of a body. Doesn't show how she came to die. But he absolutely cannot say he pled guilty to disposing a body. And I hear what your point is. Like, hey, they say it's not evidence, so can he just say whatever he wants? No, that would be, he'd be in big trouble for that. Big trouble. And I'm trying to see if anybody knew if he had time left on his federal sentence or how much he got. Let's see. Let me see. We can Google that shit. Sorry, I have to type with one hand, so it's not easy. All right. In February of 2024, he was sentenced to 37 months. So there you go. So yeah, he's still, well, February 2024 to February 2025, he could be done. Yeah. I think it's over. Sentence is running February 2020, so it was 24. Oh yeah, okay. Right, because it's over 2 years. You know, I can't even think. My brain. So yeah, he's still in his sentence. Because I think there might be at 85% federal. Oh. Sorry, guys. I'm dealing with my issues with my shoulder. Well, Ulala says if he's found not guilty, yeah, I think he can get her life insurance if all he did is dispose of her body. But I'm not an insurance, you know, I don't do anything with insurance, so I don't know. I think his house arrest terms were pretrial, so that's sort of come and gone. Yeah. All right, well, I guess we'll have to see if either side called the judge and said, you know what, we'll take that extra half hour, because I guarantee they probably need it. But maybe not. I mean, the thing is, there's not a lot of issues here, like the judge was saying. Like, a lot of times you have to deal with somebody's made, you know, an inconsistent statement, and we don't have any of that here. There's a lot of things that we don't have. One of the things I also wanted to pull up was, where was I? I had another, the direct and circumstantial evidence charge that they talked about. Just talks about there are two types of evidence that you may use to determine the facts of a case: direct evidence and circumstantial. You have direct evidence when a witness testifies directly about the fact that is to be proved based on what that witness claims to have seen or heard or felt with the witness's own sentences, and the only question is whether you believe the witness. You have circumstantial evidence where the witness cannot testify directly about the fact that is to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences or conclusions from them about the fact to be proved. Now, this is a Massachusetts instruction, and it gives a optional example. So it's like the judge doesn't have to give this, but let me give you an example. Your daughter might tell you one morning that she sees the mail carrier at your mailbox. That is direct evidence that the mail carrier has been to your house. On the other hand, She might tell you that she sees mail in the mailbox. That is circumstantial evidence that the mail carrier has been there. No one actually saw the mail carrier, but you may reasonably infer that the mail carrier has been there because there is mail in the box. It goes on to say these are the two rules to keep in mind about circumstantial. There are two rules to keep in mind about circumstantial evidence. The first rule is that you can draw inferences or conclusions only from facts that have been proven to you. The second rule is that any inference or conclusions you may draw must be reasonable and natural based on your common sense and life experiences. Thanks, babe. But there's another rule, because that's 2.02, and then there's 2.24. This is an old edition. I wonder if it's still... No, this is later. Okay. So I'm not gonna... Looks like they changed it maybe in 2011. I don't know. Maybe they didn't. Hopefully they'll read all of them. So Bob's coming back here. Well, I mean, I guess we could put up a poll when he comes back because there's no more evidence. I dipped out before I heard the poll yesterday. Did he give the results of the poll yesterday? Does anyone remember where we ended? Let's see this coffee my man made me. It is exceptionally hard not to bend your elbow, not to activate your bicep at all, which is why they want you to stay in the damn sling for the shoulder too. But, you know, it's really hard not to activate your bicep, which is very important apparently for me at this present point in time. Yeah, I don't know, guys. This is... All right, Melissa said that the majority didn't prove intent. And I don't think that necessarily changes here. I think we could still get a second degree charge. But any hope of the defense that they were going to get a not guilty of any homicide charge, I just think just because of human nature, they want to find this man guilty of something. And even though the judge says, don't concern yourself with sentence and blah, 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 they're going to be back there in their own heads thinking, well, I'm not letting him walk out of here a free man. He chopped the mother of his children up and scattered her pieces about the city. So that's... But again, it's Massachusetts, and the temperature there is like, they know. They got the power. They know. This can be a hung jury if I decide that I'm not going to agree with you guys. And, you know. Right. So Deja Vu says, and I think that is going to be huge here, because without him testifying, the defense is going to be talking about how all of the searches and everything, it's just, you know, indicative of disposal. And then the state's going to be like, yeah, well, let's see what he tells us, what he's trying to dispose of, how the body came to need disposing. We know how the body came to need disposing because he searched for how to dispose a body after a murder. Now, I know Bob made the point while it was happening, and the defense will likely make this point. Well, he started with how to dispose a body, and then how to dispose a body when you really need to. And he had to search that extra word to get results that mattered. You know how they don't know that? Because he didn't testify. They didn't put on anybody to testify about what little you find when you search how to dispose of a body when you really need to, and that they're still just talking about actual legitimate ways that people dispose of bodies. Because I did the searches. We did them on the live. They weren't bringing back shit. Which went to Bob's point that, well, until he put in how to dispose of a body after a murder, he was getting a bunch of like, call the funeral home, you know? All right, we got a new super here. Let's see. Okie Angel. I am fixing to have shoulder surgery on the 18th on my dominant hand. Oh boy, 6 weeks. 6 weeks. And I'm hoping that you are, married or have like a best friend, family member who is going to be available to like do everything for you. Tie your shoes, scratch your face. Well, no, I guess you can scratch your own face, but pull up your pants, put on your bra. It's a fucking mess. It's a fucking mess. And, they don't tell you like what kind of clothing to get. You've got to get really loose and things that zip and then you can slide in or snap. Bob got these like they kind of end up looking similar to hospital garb that I have at home that snapped on. There are so many things. There are so many things. Don't expect to sleep. Try to get the strongest pain medicine they will give you, because they will try not to give you the strong stuff because, we went through this whole period where they're just giving Percocet and Oxycontin anybody and everybody, and now you can't get your hands on anything stronger than an Advil and a Tylenol. They'll send you home with some pain medicine to begin with, but it just might not be strong enough. So just don't be shy about pushing if you need something stronger. So, yeah, 6 weeks in the sling for sure. No driving, no pulling up your own pants and putting on your own bra. If you don't have the bicep done, you can at least use your other arm from the hand to the elbow, which is actually extremely helpful. All of the cheats that I have developed over the past weeks have dealt with me using the bicep in a way that I shouldn't, because I didn't really think it was going to be that big of a deal, but apparently it is. So, yeah. We got a new member, and it's Jade for Justice. Where's Bob to give family hugs? But welcome and family hug. Now I feel like he is, I don't know what has transpired. He's making coffee and now he's disappeared. But yeah, I was telling my physical therapist 2 days ago, I'm like, how does a single person get this surgery? Like, how does someone who doesn't have another human being to be with them 24 hours a day to do everything for them, including like getting all the wrap and icing stuff on that you need, the first like 10 days nonstop. Like, how do they have this surgery? You can't be single or not have that person available to you and get this surgery. I just don't see how. I just don't. Unless you're just going to sit there in the same clothing and never shower or move, I guess you could do that. I'm just going to stay like this for at least 10 days until your first follow-up or until your first PT. I don't know. I'm calling up to Bob like, hey, yo, you got to get on here. You know that I can't keep the conversation going like you can. For those of you who've been with us like long enough, if he used to leave, I used to just be like, oh, I wonder where Bob is. He's probably doing something. He'll be back soon. Oh, yeah. I think I hear him now. Because it's really difficult talking to no one. Well, talking to y'all, but, you know, talking to no one, like when there's nothing going on to talk about.
Oh, did you miss me?
Oh, so much.
Wow.
Jade for Justice really needs a family hug.
Wow. Aw, family hug. All right. So we're still killing some time.
Yeah, I think that it's very likely. I think it's very likely that one or both sides was like, yeah, you know what? We'll take that 11 o'clock, Your Honor.
Yeah, I mean, I was reeling because there was no ice in the ice machine. So,
Oh,
man,
sorry.
man, oh man, man, oh man. Speaking of which, do you need me to bring your ice machine down there? Do you want that thing?
I don't know. I think I'm all right.
See, this is what she does. She does. All right.
I mean, I could, but I need the whole, you know, rappy get up thing, and that just takes a whole thing.
Takes like a minute, if that.
Well, we can do it maybe after, like, you entertain the people for a little.
Wow. Okay. All right. There were a couple things. So I woke up this morning way too early. I fell asleep pretty early though last night.
You really did.
You
were snoring so early.
I was.
A light snore, but yeah.
Yeah, I was tired. I was tired. All right. So here, this is one. So I woke up this morning and it was just the most adorable thing I'd ever seen. So I have to show this just adorable picture, which you guys will love so much.
Something that Nook was doing.
No, but it is a dog pic. It's one of our very own. So Bailey DM me in Twitter and said, "Oh, she was talking about our little guy. He's got that wheel. Oh,
is that him?
Yeah.
Oh,
How adorable!
So cute.
How adorable is Bailey's pup? So sweet.
Oh,
So sweet. I love it. I love it. I love it. I love it. So that's really super cute. So thank you for sending that. I always love to see your furry family members. They're so sweet. And then there was something else. I can't. Whoa.
I just didn't know. Like, I didn't want you doxing people. I didn't
Chuck.
realize it was
That wasn't
X.
doxing somebody.
I didn't know what it was. Like,
what are you talking about? That was a fucking picture.
I'll be right back.
I don't dox people. I don't even know what doxing is. I know what it is, but I don't understand why people do it. It's so weird. I just don't. I don't know. I don't. So maybe this will explain it. So this thing that I found, this just popped up on my thing, and I know we got some old heads in here. I know we got some folks that grew up in the 70s in here, and this fucking thing really resonated with me, and I felt that it was like, I was like, I'm gonna actually,
who grew up in,
despite the fact it's AI narrated,
people who grew up in,
which is irritating to me, but what it's saying is pretty fucking profound and spot on. So I thought that the old heads in our audience would enjoy this. I just thought it was like fucking nailed it. Yeah, we got some old heads in here. We got a lot of Gen Xers in here, which I am a proud Gen X, the greatest generation of all time. So I thought you guys might enjoy this, and I thought that the new heads might learn something. So let's watch it. It's only like 6 minutes. I'll keep an eye on the judge, see if she comes back. But let's check this out. I thought it was cool.
There's something fascinating about people who grew up in the 1970s, and psychology can prove it. If you grew up in this era, your brain developed during a rare evolutionary window, a time of total freedom, combined with genuine responsibility.
I guess, yeah, that's as big as I can make it.
And here's what's interesting. Most people who grew up in the 70s look at our current generation and just laugh. Not in a mean way, but because they know something the rest of us don't. They experienced something that can never be recreated. A time so magical, so free, that decades later, they still say things like, I wish I could go back and stay there, or we really didn't know how good we had it. To put it even perfectly, we grew up on hose water, we were feral, and it was glorious. So what made the 70s so special? And more importantly, what did it do to your brain that makes you different today? The first trait is what researchers call
See if I can boost it.
self-directed problem solving. And it started with one phrase every 70s kid remembers. Go find something to do. Or I'll find.
Yes. Yes. That phrase. That was like, as soon as that came, I'm like, oh, hello.
Find something for you to do. You knew exactly what that meant. If you dared say you were bored, suddenly you were folding clothes or sweeping floors. So you learned fast. Figure it out yourself. Studies on unstructured childhood show that children who had to create their own entertainment developed significantly stronger executive function and creativity. You weren't handed activities. You weren't scheduled. You had to invent your entire day from nothing. This is why you devoured books,
Yes.
explored on your bike for hours,
Yes.
or spent entire afternoons in the woods building forts.
Yes.
You can say to yourself, I was never bored. I devoured books or explored on my bike, loved my independence. Your brain learned something modern childhoods skip entirely: how to generate purpose from emptiness. Now, that explains your creativity, but it doesn't explain why you seem almost supernaturally calm in chaos. That comes from this next trait: adaptive risk calibration. You grew up climbing trees that were definitely too high,
Yes.
riding bikes without helmets,
Yes.
throwing rocks at each other,
Yes.
setting things on fire with fireworks.
Yes.
You can say, that was our internet. Every scraped knee, every minor disaster, every
No, they
close
didn't.
call was teaching your nerve.
I'm gonna push back on you, Spit. Not it's not the same. I'm the source. I lived it. And I raise kids. I have 2 millennial children. As soon as fucking smartphones were introduced to society, it changed everything, and not in a good way. It was different. It was different. See, here's the thing. I lived through both of them. Millennials didn't. You can't speak to what happened in the 70s because you didn't live it. It was just different. Like, millennials weren't allowed to be latchkey kids. At least most of them weren't. Like, I was a latchkey kid. When my parents divorced, my mom had to work. I came home literally with the key. And I had to, I fucking took care of myself. Went out and played with my friends. Got home when the streetlights came on. That was it. Very different. Very, very different.
Nervous system, something crucial. Research in developmental psychology shows that children who experienced physical risk in play developed better threat assessment and lower baseline anxiety as adults. Your brain learned the difference between actual danger and manageable risk by living it, not by watching it on a screen or having a parent intervene. You broke bones, you got scars, and that honestly felt like a Medal of Honor with a story behind it. This is why you could be fascinating about people who grew up in the 1970s.
So I'm going to tell my story, one of my stories.
Let me get to where it was. Okay. You got scars, and that honor.
So I think, yeah, yeah. Somebody left the chain out there too. I understand. So my story, one of my stories. So the rock fighting, I'm assuming that was only stupid boys, but the rock fighting was a thing. Like, if you can imagine a world in which you'd pick up those like rocks, like about this size, those quartz rocks, and you'd throw them at one another. from a distance, from a great distance. So I was in a rock fight, caught one in the head. This is the first time I ever bled from my head. I thought so the rock hits me straight, like I think somewhere like up here. Rock hits me straight in the head, and I start bleeding like my entire skull was caved in. I couldn't believe how much I thought. I was like, oh my God, I'm dying. So I'm running back to our place, and I'm screaming, and I'm like, mom, and like I've blood pour, like my whole face covered in blood. She cleans it all up, and she's like, yeah, it's a tiny. I'm like, do I need to go get stitches? She's like, no, man, it's like a teeny little wound. But I'm like, but all that blood. I'm like, what? She's like, trust me. So that's not the good story, but that's just like the rock fighting was a real thing. Oh, good. That's good to know. So I think I'm about 10 or 11. And so my parents are divorced at this point. My dad's best friends lived out in this, at the time, it was a pretty new suburb, and it was called Bolingbrook, and it's in the southwest suburb of the city. So it was like driving there felt like it took forever, but like we spent a lot of time out there, like at my dad's best friends, and their daughter, they only had one child. I was an only child. I have a half brother, but at that point I was an only child. And we'd spend a lot of weekends out there because it kept me occupied. I'd hang out with Carrie. I got to be friends with everybody in their neighborhood. And so one summer, I spent the entire summer out there. I think, like, in retrospect, when I look back at it, I'm like, I think my dad was working. He'd worked something out with them to where he's like, can he just stay out here for the summer? And, I'll come visit. And they were, of course, like, yeah, of course. So I became good friends with this kid that was across the street, and back behind their houses, there was a huge field, like which I'm assuming at this point, because it wasn't corn, so it was probably like soybeans or something. I didn't know at that time, but way, probably about 500 yards out there, there was like a thatch of woods, and there was this big ash tree. So like one time we go back, and I'm like, let's go explore. And so we're exploring, we get out there, and we notice that somebody had started to build, in this big ash tree, started to build a tree house. And they had like the plywood flooring on the first level was already laid out. I'm like, holy shit, man. I'm like, we could finish this thing. We could have our hangout spot. We'll have our own tree house. So we get all excited. We go and gather some wood and get, some nails and some, bring our hammers, and we're going to try to build a tree house beyond what was already existing there. So we get up there, we climb up, and you know how like a large like oak tree is, you've got your large limbs. And so you had probably, it was about I'd say a 5x5 piece of plywood that was kind of the floor. And then in the limb that was coming up from the plywood floor, which was about 10 to 12 feet off the ground. So I noticed that somebody had built a wood hammer, where they had taken cut pieces of 2x4 and hammered them in to this large limb that was leading up to what would have been another floored area. So it would have been like a 2-tiered tree house. So I'm like, I'm going to go up and see what's what. And so I'm climbing up these things, and there was probably about, I don't know, 10 of them, maybe 1.5 feet apart, maybe 2 feet, so, I get up, I pull myself up onto the first one, and I'm about halfway up. And I notice that the nails are very rusty. So while I'm sitting there, and you know how shit, like when some kind of sudden unexpected thing happens, time moves differently. It feels like it's kind of like in slow motion. That's what this felt like. So I'm climbing up this thing. My buddy's still down on the ground, and all of a sudden the piece of wood starts pulling out of the tree. Like the thing that I'm holding, my hands are attached to. So this thing's pulling, and there's nothing you can do. Like there is no, it happened so quickly. In my mind, it's in slow motion, but in real life, it was like fast. So there was so it pulls completely out of the tree. I go falling backwards. Okay. So I was probably about 7 or 8 feet above the plywood. I hit the plywood thing, on my back. I bounce off the plywood and then go flying off the tree. And which like I said, is probably about 10 to 12 feet. And I hit the ground. And I'm like, and I kind of like pop up immediately. I'm like, oh my God. I'm like, I survived it. I'm like, I'm fine. I'm like, I didn't break anything. My legs are good. My arms are good. I'm like, I can't believe that. That was like amazing. And he's like, oh my God. He's like, look at your knee. And I'm like, what do you mean? He's like, look at your knee. I'm like, just tell what's wrong with my knee. Cause I'm like, I still am not good with blood, but back then I could not stand the sight of blood at all. It horrified me. I'm like, what's going on with my knee? He's like, it's bleeding. I'm like, what do you mean? Is it bleeding bad? And he's like, yeah, it's bleeding pretty bad. So I'm like crying hysterically. I'm running, limping through this like huge soybean field. I go busting into the house. I'm like, Aunt Janine. I was like, I'm hurt. And she takes me up to the bathroom. She cleans it off. She's like, oh, it's like, yeah, it's a pretty bad cut. I'm like, does it need stitches? She's like, yeah, I think it might need stitches. So she takes me to the hospital. I get like eight stitches across my knee.
Is this falling from the tree story?
That's the falling from the tree story. So, the point being that this thing like really resonated with me because like that's true. Like that kind of calculated risk. Clearly I had to know that there would have been like a possibility that I'd fall. I didn't take into consideration that the wood ladder would come out of the tree like that. But it was, and I've told that story my whole life, that whole falling out of the tree story, Okay. Good luck. Good luck. Are you telling me to pause the camera or stop the camera? All right. Huss. All right. I'm going to restart this.
Honestly felt like a Medal of Honor with a story behind it. This is why you can walk into a crisis and just start solving it while everyone else is panicking. But here's where it gets deeper, and this is the piece most Gen Z will never understand. You carry what researchers call comfortable solitude capacity. You spent hours in your room listening to music. You laid on the grass, just talking to friends. You explored alone.
That's
not
me.
because you were alone.
Oh, what did I learn? I learned many things from that. No, that wasn't it. I definitely did not learn to not be an asshole. I did learn never to get up in a tree like that and not make sure that it was not safe, not secure. Test those things out.
That's it.
Yeah. I mean, yeah. That was a pretty important lesson. Like that lesson of like making sure that something is safe before you engage in doing it is a pretty big fucking lesson.
That's what I'm saying. It's broader.
What is that noise? No, you turn the TV on. What is that? What are you watching there? All right, let's continue with the lesson for today.
But because there was no screen demanding your attention every 3 seconds.
Yes.
Studies on pre-digital childhood found that people who grew up before constant connectivity show significantly less anxiety when alone with their thoughts. In fact, recent research had participants choose mild electric shocks over sitting quietly for 15 minutes. You'd probably find that ridiculous.
Wow.
You learned early that boredom isn't an emergency. At that time, you can never get bored as a kid. Your brain never developed the addiction to constant stimulation that defines modern life. This is why you can wait in long lines without losing your mind. The fourth trait is something psychologists call analog patience, and it shaped you in ways you probably don't even realize. You waited for your favorite show once a week, no binge watching. You took photos and waited days to see if they turned out. You wanted to talk to someone, you memorized their phone number and hoped they were home. Research on delayed gratification shows that people who grew up waiting for things have better impulse control, better relationship outcomes, and better career success. Your entire childhood was training in patience that modern life actively destroys. This is why instant gratification doesn't satisfy you the way it does for younger generations. And here's the trait that ties everything together. You have what I call unsupervised autonomy wiring. At 8 years old, you left the house in the morning and your parents' only rule was be back before the streetlights come on. Nobody knew where you were. Nobody tracked your location. You rode your bike to creeks a mile out of town. You played in the woods. You went to neighborhoods far from home. And a random stranger might even offer you a lemonade and sandwiches after playing in a creek all day. But today, that would result in police calls. Back then, it was normal. Research on childhood independence shows that children who had freedom of movement without constant supervision developed stronger internal motivation and decision-making skills. You had to assess situations, make judgment calls, and deal with consequences yourself. Your parents weren't your friends, they were the authority, and they trusted you to be competent. This is why you can plan, adapt, and think critically without external guidance. Every time you look at today's world and feel out of place, remember this. You're not outdated. You're carrying forward capabilities that are going extinct. The independence that looks like coldness, that's competence. The comfort with silence that looks like antisocial behavior, that's depth. The ability to wait that looks like apathy, that's discipline. You survived a childhood that would get parents arrested today, and it didn't damage you, it built you. Most people will say, I feel honored to have been able to grow up this way. Or, we lived through the best decade to be a kid. And they're right. For a brief moment in human history, childhood was both completely free and genuinely formative. You got to experience something that doesn't exist anymore. A world where kids were civilized and feral at the same time. Drop a comment if you're a 70s kid and who thinks it was the best era to grow up.
I mean, all that shit's true. Gospel. Absolute gospel. All of it. All of it. All of it was gospel. It's all true. I mean, I have come, the reliance on our devices is so ingrained now. And I just hate the phones. I hate the screens. I hate them for our kids. I hate them. I hate them. I mean, I don't know if I told you guys this story when I was down in, I can't remember if I was in Indy. Oh, no. I think I was in Fort Wayne for one of the Richard Allen hearings. And as we know, Gall didn't allow you to bring your phones in. And like I was staying at a Marriott and it was an early court morning. I didn't know if there was going to be a line. So I left the hotel at like 5:30 a.m. Yeah, I'm on Twitter all day, Kraken, and I fucking hate it. Like me marketing is a different thing. That's not me scrolling. Like I'm never doom scrolling. When you're like, Bob, are you on Twitter all the time? Yes, but I'm tweeting. I'm not reading anybody's shit unless it's Bears content. I am guilty of really, really devouring a lot of Bears content. But in terms of like the true crime world, I'm really not reading much in terms of scrolling. I never scroll on Insta. I never look at reels. I just don't do any of it. But I do tweet, but I use my Twitter account as a marketing tool. That's part of my business. So, but at any rate, I leave the hotel really early. I know that I can't bring my phone, and I'm only like 3 blocks, 3.5 blocks, 4 blocks away from the courthouse. And I kind of look at my phone. I'm like, all right, these are the, I pull up the GPS, I get the directions, and I try to commit it to memory. And like the second I fucking walk out of the hotel, like I forget which way I'm supposed to turn. And it's 5:30 in the morning. you know, and I start walking. I didn't think to ask one of the clerks, or I might have, and they were like, I don't know where it's at. I'm like, okay. So I literally start walking, which I think is the direction of the courthouse. And I soon come to realize after I've been walking for 15 minutes and I'm looking for this rather large courthouse in Fort Wayne that I'm not seeing it. I'm like, where the fuck is this place, man? And I'm looking for any business that's open and there's nothing open. There's nobody on the streets. Like it's so early that you're seeing, you know, like newspaper trucks or whatever the equivalent to what those used to be back in the day when they used to deliver papers, you know, the trucks that would deliver the Tribunes and the Sun-Times and shit like that, or the Fort Wayne Star or whatever it is. So there's nothing out there. Like, and I'm walking around wandering, lost without my device. And I'm like, oh my God. So like I finally find a diner that looks like they're not open yet, but I see them in there preparing for the day in the morning. So I'm over there. I'm in my suit because I was suited up for this particular day. And I'm like banging on the door. I'm like, hey. And I think that they think like I'm a fucking Bible salesman or something. The guy's like looking at me. I'm in this suit with like my overcoat. So the guy doesn't even answer my question. And then finally, like I walk 2 more blocks, I find another person. Person's like, oh yeah, up here to the left.
We're back on the record.
Story, I end up getting lost on the way back to the hotel too. That's how dependent I am on GPS. Like Allison's like, didn't you grow up in the city of Chicago? Like, how the fuck don't you know where we're going? Like when we leave, I'm like, I haven't like had to drive without GPS for so long that I forget everything. And it's like a constant like thing where she's ragging me.
I just
don't
like to poke at you a
understand.
little for that because it's, you know.
Oh no. Well, I get super defensive about it. I'm like, I
I
haven't fucking
know.
looked at a map and like I haven't driven without GPS in 20 years. I don't know where anything is. I don't know what the street it's. Yeah, well, I didn't have a map handy, Tiff. I had just left a hotel. So it was point is it's time for us to untether. It's time for us to untether from the devices. It's not a good thing. It is not a good thing.
Not a good thing. For those of you who are just coming in, the defense has rested. They're not putting on any evidence. Brian is not testifying, and the jury is not hearing that he has pled guilty to disposing of the body or lying to the police. And we are going into the jury has been dismissed for the day to return tomorrow for closings. And we're about to go to the jury instruction conference.
Yeah, Chicago's a grid too. Like I don't know there's a more grittier city.
Yeah, Chicago's a grid because there was a big fire and they got to just reconstruct the entire city. So they did it as
a grid.
Gritty and perfectly as one could. So Bob used to know like the numbers though. Like
right. Like I would know like North Avenue was like 1600 North. Like it all vanished. All of my knowledge of the city and what was like, obviously I still know that Madison Avenue is 0. That's the delineation between North and South, you know, but it's like, and there's really only 2 angled streets. There's Elston and
all right,
Milwaukee.
people, we don't need this much detail. Let's go to it.
Like people think that like the only people that enjoy jury instructions are you and me and other lawyers.
In the matter of the Commonwealth versus Brian Walshe, indictment 2023-0091.
Especially this one, they've already pretty much said everything that would be shocking.
The interesting ones, yeah.
Right.
That's true. Go out to Colorado, I'm like fucking like nomad. I'd be horrifically lost in Denver.
Did you put these supers up?
No, I was busy blabbing.
Yeah.
I was, you know, I'm pretty good at entertaining.
So I know you haven't had a long time to look at them, but we'll take a stab at seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right.
Thank you.
So,
Jared.
my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or
In addition,
an
or
extraction or an addition. What's the first page for the Commonwealth?
That'll do it.
Your Honor, I'd say page
Why me?
15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number one.
Page 1?
I think it is. She just took it.
Are you joking?
No, it's, I'm sorry. Premeditation, I'm sorry, I have it one here, but I meant what my notes are saying, it's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
Oh, we'd be here forever if we were starting with page.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to, otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that
yes,
the section B regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion.
denied.
Rejected.
Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours.
Which you've
assessing
already
the
said you don't
propriety,
love,
but
Your Honor.
I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully
Briefed.
preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mhm.
This judge will change an instruction.
So
She's got no bones about changing an instruction.
15
He
on
agrees
to
with it.
16. Anything from the defense before page 15, other than what you just mentioned?
Page 9,
Yes, counsel?
the instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Ana Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
That's disposal.
what the
Dismemberment.
breadcrumbs,
Why don't you argue, and then I'll let them make, I don't want to make their argument for them.
Your
That would
loop back,
be,
I might have spoke over a word he
but-
said.
But I,
Like here?
One more second, right there.
about the breadcrumbs that the
Oh,
Commonwealth
one more
put down.
second, sorry.
being of Ana Walshe
Okay.
used that caused the death of Ana Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue, and then I'll let them make, I don't want to
thought
make their
maybe he
argument
said
for them.
disposal.
That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and then, you'll have
And
an
I'll tell you
opportunity.
how
to
I
rebut.
agree with them.
I understand the admission of the exhibits. I understand
Talked
the
already,
admission of the hacksaw. But to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was.
Pause it
And
a sec.
given the state of this evidence,
Okay.
this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, pause right there.
I know, hon.
Sorry, I would have added, okay, because I want to keep making a record about the they don't know he's pled guilty to disposing of the body, that all of that goes to dismemberment. It seems like he does not want to admit that this guy dismembered the body. And if without that, then all those weapons are used as potential murder weapons. I don't know
Right.
how you come to murder someone like that, but and he bought all that stuff after. That should be the argument right there, is that the evidence suggests he purchased all of those things after she was deceased. The state's own theory is that he unalived her January 1st. And then that's why he pretended he didn't have a phone until January 2nd or whatever. I mean, they surely don't think that he went out and purchased all of that stuff and like brought it all in the house and was like, hey, come over so I can use this
Where
stuff.
the hell were the kids when he's doing all this dismembering?
Maybe that would have
That
been
is
one of the
not like a 10-minute job. That takes hours and hours and hours and is like loud and horrible.
bloody and
Oh my God. Like, I just don't.
so I would have just put on the record that the evidence suggests that was used in the disposal process, and it's highly prejudicial, especially considering that Your Honor excluded the jury knowing that he was in fact charged with that offense and that he did in fact plead guilty to that offense. And for that reason, it's even more prejudicial. I would have added that to it.
I want to see. I'm curious, the judge alluded to breadcrumbs. So I want to see if the state picks up what she was putting down. Because she's like, well, I'm not going to argue the state's argument here, but I'll wait until they argue it.
I think those are the breadcrumbs that she's talking about.
I mean, maybe.
Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA.
Yep. That's what I was going to
One
say.
can infer that an object was used, a dangerous weapon was used to murder Ana Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant, throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here, and would ask that the court keep that instruction in.
What?
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
Right.
No, she didn't say that
She did.
because there is no DNA on the knife, right?
That's correct, Your Honor.
So,
She
but I
did just
hear you
say that.
knife.
Yeah,
Yeah.
she definitely said that.
The defendant was used regarding getting DNA off of a knife, using a dishwasher to remove DNA.
Okay, she definitely said getting DNA off a fucking knife.
Because that's what his search was.
Is she gaslighting the judge? And not like, see, this is irritating if you're a lawyer. Like, okay, we just heard her say it. She's now denying she said it, and the judge is saying, well, she didn't say it. Yes, she did.
And why isn't he saying, and Your Honor, she just made her own argument that he hadn't purchased the freaking hatchet yet. He went to the dumpster before he purchased the hatchet. But that's what I was going to say, is that dangerous weapon was that knife that they found in, it was not with all the other stuff. It was up on a shelf. Right.
Like in that little cubby hole.
So
One can infer that an object was used, a dangerous weapon was used to murder Ana Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant, throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here, and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
All right, so
But I
real
did hear you
quick,
say knife, didn't I?
No, I didn't hear her say knife just now.
There was a
Yes.
search.
There is the knife above the,
There is a knife, but there is also a search in the web history in the defendant's.
I remember
computer
that. And then
regarding,
it was, the search was specific, as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
right.
Your Honor, may I? I believe
The trip was
that
January
I can
1st,
answer this question.
5/12. Vin Liquors.
There is a slate.com article
Right.
that the defendant went to that was regarding getting, can DNA be removed from a knife?
Yes,
Then the dishwasher is,
following that, right?
is follows that, and it's,
Keep
can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right,
And then page number 4, the DNA off of a knife,
yes,
is page 578.
let me
That's-
get there.
Okay.
I'm there.
Okay. Then if you go to page 670,
Hold on, I just want to look at these.
sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the, Vinton's Liquor is also on the 1st, it's at night, because I remember it being a little dark. What
yes,
time is
Your Honor,
that?
it's dark at the, at Vin Liquors.
5:30, 4:30, something
About
like
5
that?
p.m., Your Honor.
All right. Okay,
And so if you were to go to page 670,
yeah, let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
right,
And then on page 671, there is record 2433. Is it possible that a knife that
which had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap?
yes, Your Honor.
Mhm.
And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
Mhm.
So I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see the way, what our argument is that those searches show the reasonable inference that a weapon was used.
What?
Well,
All right.
what do you
There are
mean,
the
what?
breadcrumbs.
I mean, so just so everybody knows, 5:12 p.m. January 1st, Walsh is seen on video at the liquor store, the Vin liquor store they're talking about, which is near his mom's apartment, disposing of, a heavy bag. 5:41, he goes to Lowe's and he gets a mop, bucket, the bleach, the hammer, the wire snips, a hacksaw, a knife. Hold on a second.
Senior.
Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect to help guide the jury to avoid speculating about any and all of the tools and weapons so-called weapons. I just think the jury's gonna think, oh, I can cherry pick whatever I want to,
Like a hacksaw.
call it a weapon, and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the clerk today with suggested language.
All right.
Yeah, I mean, essentially the breadcrumb trail is like, look, all the shit that he bought after the fact, which was clearly, at least in the defense's mind, used for disposal and dismemberment or whatever, you know, and this concept that he went and dumped this shit prior to would be him getting rid of the murder weapon. I mean, that's their breadcrumb trail, you know, and then he makes the search about the knife. So, I mean, I think it's a reasonable inference, to be honest with you. I mean, it's not much of a breadcrumb trail, but it is one. You know, the problem is where is the evidence of where the homicide took place in terms of forensic evidence left either in the bathroom and or the bedroom or wherever the homicide took place. Like there was really no evidence to that effect. Like they didn't find anything in the drains. You know, it's almost impossible to completely clean up where you're going to get every iota of blood. Plus, when they're coming in and using the technology that they have to see if you've used cleaning supplies, like none of that exists.
So let me just finish the January 1st stuff. So what they're saying, okay, is that he disposed of this bag at 5:12 p.m. on January 1st. So that stuff has to deal with the murder because he hasn't started the dismemberment yet. That's the argument, right?
Yeah.
So because of that, the evidence suggests he used a knife because he searched how to get blood off of a knife.
Correct. That's their breadcrumb trail, which I think is a reasonable inference. I mean,
I think I think he used some kind of knife. I mean, who knows? Maybe not. But he could have. All right, let's just devil's advocate it. He could have been searching again, trying to keep his searches vague. He doesn't want to say how to get it off a hacksaw.
But he didn't have the hacksaw yet.
I know. I'm just saying. So then he went to the Lowe's and he got all that stuff. Then he went to the CVS about 40 minutes after that and got all the hydrogen peroxide and stuff. And then right after that, he went to the Stop and Shop and got ammonia. So he's just driving place to place, getting all his supplies.
See, my thing is based on the lack of evidence. I don't think that he used a knife. I think he strangled her. I think he, snuffed her out with a pillow over her, like something like that. Like, I don't think there would just be evidence of it somewhere. Like you cannot vanish all that type of evidence. And especially like the cleaning effort after the fact in terms of where this may have gone down. It's either, it would have been either in the kitchen, the bedroom, or the bathroom, I would assume. Maybe the living room if they're having an argument.
Were they able to
Yeah, but we don't know when he cut his finger, Ren Rocks. Like, to me, the finger injury happens when you're trying to dismember a human body.
Right.
Which is a fucking massive undertaking. It's like, I've never done it, but I've seen it done on movies and it looks brutal.
So tell me if I'm right. They found all of the stuff at like the transfer station, right? Obviously not in each of the dumpsters because all the dumpsters were emptied. So there was no evidence about where, if there was
Amanda's
a way
got a good
to,
point.
what?
That I think that the rug that he ended up replacing was in fact in the living room. So
Right.
that could be evidence of.
But he also had to do the bathroom stuff, and she was wearing her slippers. I honestly think this started in the bathroom.
Yeah.
That's just like my opinion, because of her wearing her slippers and him wearing his slippers.
Yeah.
Like, I mean, yeah, he could have been wearing his slippers because it's easier to
No, I
drag and
I think you're right. I like whatever happened that night. I think it was born out of an argument that got heated quickly and then turned deadly. You know what I mean? Like, you're not wearing slippers if you're going into this situation and your plan is to kill your wife. Like, that's not they're just not secure footwear for that type of shit, man. It's
and
like,
she's wearing her slippers, so she
right, they
hasn't gotten
both
into
are.
bed yet.
They're both in their PJs or their robes or what have you, whatever.
Right.
You know,
Right.
that's clear. But yeah, that's a good point about the rug, you know.
He had to replace all that stuff in the
Because even if he's just rolling her up in the rug, they still found evidence of blood in the rug, right?
and tissue. They found tissue on the rug.
I mean, it could have been a thing where he rolled her up in the rug and then brought her down in the rug or up in the rug.
Or started there and then went to the bathroom.
God
started in the
forbid the
bathroom,
kids
went
wake
there.
up and like, Daddy, where are you going with? What's
Right.
wrong with mommy? Oh, I'm just carrying this rug around, dudes. Don't worry about it.
Right.
That
right.
kind of shit. I don't know.
As of the time,
The rug
as of
was in the
this
living
time,
room, but he also
the
replaced
instruction
rugs
is
from the
going
bathroom.
in, and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs.
For the dangerous weapon she's still talking about?
Which
She could have been, like with the slippers, I think eliminates the concept of her taking a bath and her drowning her. Like, she's already, whatever she's doing, she's got her slippers on. So she's already in her sleeping gear. So, yeah.
this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about
a really good judge.
the prohibition against any speculation or guesswork.
That doesn't
and
mean
see
we
if I
necessarily
feel like it accurately and completely addresses those concerns.
like
And I'll be open to
necessarily
seeing
agree
whether
with
there's something
every
else
one of her
that
rulings.
needs to be added to make it more easy for the jury to digest.
But she
this
thinks things
aspect.
through thoroughly. She's
That's all I can say
open-minded.
right now.
She's
All right.
willing to
We're
change.
still the defense. Anything else before page 15?
No.
All right,
Great
so now
job.
we'll move to the other side. What is your, I'm moving to page
Thanks, Iceman.
15. Did you say 15 into 16?
The impeachment by prior conviction,
Yes,
and
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being
Right.
impeached.
That's what I was going to say.
That's probably because when the defense, I lifted it from your instructions
I don't know why
and
he
at a
gets
time when I
impeached if
think
he didn't testify.
that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor, that
That sentence is okay.
it's on the next page only for the limited purpose, and I suggested
I see,
limited
I see,
purpose.
I see.
I don't understand why he's being impeached if he didn't testify with a prior conviction. I don't understand that. I don't know what I'm missing here. unless it's saying that you can't impeach him with it.
So does the whole thing come out?
Yes.
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand
You
the
can't impeach the
complete
non-testifying
circumstances
defendant.
of the situation in the home at the time of the events at issue here.
I just don't
Well-
understand what we're fucking talking about. Am I insane?
I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I
Exactly.
did put that
Thank
in there
you.
last night,
Thank you.
based on the information I had at that time.
Which
But
was he was
that
going to testify.
prior felony conviction is no longer impeaching Mr. Walsh.
Okay.
So it just
thank
seems
you.
to me like it
Jesus.
should be out.
Right. I'm like, am I insane? Why are we having this discussion?
You think it should be out?
Yes. There's no doubt it should
Maybe
be
it
out.
should be out.
Yes.
I mean, it's no longer impeaching him, and
No.
the relevance of the prior federal conviction
it should actually
goes
be
to motive
a
intent.
curing instruction
to
that
me,
you
right?
cannot use it.
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right, my present ruling is that's whole section's coming out now.
They let all that in the defense because they thought he
The
was
reason the
taking
impeachment by
stand.
prior inconsistent statement is now in italics is, I'm sure that happened with some witness,
I don't think so.
but I'm not 100% sure.
It was like one thing about the dating
Anybody?
with Magoo.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said
Yeah, I
previously.
just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and
Yes, you did.
cross-examining.
You just
I think
marked it.
The closest we got to it, I
Hammer
think,
end.
was Jem yesterday,
Right.
Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So is that enough to warrant the
Does the defense want it or not?
instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about?
Right.
So I'm inclined to take it out.
Take it
We
out.
have no objections.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
No.
Yes.
With
No.
this,
What prior bad act?
I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
And I would suggest it's a prior bad act defense, and that's why the jury needs to be informed that he was charged
It's an
with.
interesting question.
Yeah.
There's many interesting questions in this
There
case, Your Honor,
is.
no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the,
Correct, Your Honor,
Yeah,
that's
that's-
accurate.
what do you want me to add?
All right.
May have,
I'm going back.
And
I'm
in
in
the
control.
well, the fact that it was unsuccessful is some,
Wait, sorry.
false statements before his
okay, edit that the Commonwealth has.
Wait, maybe I wasn't as live as I thought.
Move it.
Sorry, guys. Because I can't remember what I want to say until Bob pauses.
Later in the instruction. Doesn't make any sense, I suppose, standing alone.
on page 27.
Here we go.
It's right in front of me, but it almost seems like we might be telling the jury different things.
But it seems, then I go back,
Sorry, guys.
blah, 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 right through to, suggestion, namely, acts involving a federal case concerning art fraud, and that he was charged within 2018 and sentenced in 2024, semicolon,
Hold
lying
on a
to the
sec.
police.
Hold on a sec. Sorry, guys. Let me see if I can just
If
see
they
where Bob
believe
was.
that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act.
All
They
right.
need to be instructed.
Sorry, did you? I had to use the facilities.
Yeah, and I took over, so I think you
So
need.
all four things would go as a federal case.
Okay, and then I
You've heard mention,
trying to get to where you were, and I fucked it. I thought you were live.
Here, just let me pull it back up.
Well, now I let yours run for about a minute, so you have to go back. We were right at where they were talking
let
about
me take a minute.
prior bad acts.
Do you want me to pull mine up
Yeah, let me just see.
and go back?
I think so. Let me just see.
Yeah, I'll just do
Yeah.
it.
I think the language comes in that
Is this mine?
You just removed yours.
You want me to go back?
Yeah, but get it
minute?
up there and I'll tell you where. Sorry, everybody. People are probably like,
I would
what the
try
fuck?
to parse.
Okay. So you want me to go back a little
Yeah, I'll
bit?
tell you when I'm looking at the words as they
Captions.
pop up.
So there,
Yep,
it's
keep
a
going.
it's a prior bad act argument.
Yeah, so and what I was trying to say, keep going. It's a little bit more. All right, I think it's right here.
Okay.
So before we start it, what we're about to hear is this argument about prior bad acts. Now the prosecution is arguing this is not a prior bad act, the disposal and the lying to the police. It's part and parcel of the murder. It's the consciousness of guilt and all part and parcel of the murder. The defense should be arguing, no, this is a prior bad act. I was saying that before. This is a prior bad act. And this goes to exactly why the defense, the jury needs to be told he was charged with and pled guilty.
Hey, how is it a prior bad act?
Because if you think of the murder as its own act,
Yeah,
then other bad acts that he did was lie to the police and
but that would
illegally
be
dispose of a
subsequent
body.
bad acts.
Well, I think they can. It's like prior.
I mean, prior is the
Meaning
word that
prior to
kills your
today's
argument.
date, at whenever you're at trial. You know what I mean?
Is that what it means?
I think so, because if you do the bad act after the first, what you're charged with, and the
Wait,
trial, it's
you're
still a prior.
saying that you think if we were going to trial on something and a crime was committed and our client has been charged with it,
Yeah, let's use like bank fraud.
and then he does something after that, the date of that crime taking place, that they can get that in as a prior bad act?
Yeah, prior to, it means before today. It's things that he has done before. It's not prior to when the crime was
took
committed.
place?
Yeah.
Really?
I mean, yeah, it's.
I mean, I'm going to trust you on it.
goes to motive intent.
All right,
seems
maybe
to me,
back
right?
a little bit more. Sorry.
Your Honor, I think there were reasons it was introduced.
The relevance of the prior federal conviction.
Okay, let's stay right here.
Goes to motive intent, it seems to me, right?
Your Honor, I think there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right.
Oh,
I'm going
way
to, my
back.
present ruling is that's whole
coming
section's coming out now.
Right. And then I think the next one came out.
The reason the impeachment by prior inconsistent statement is now in italics is,
Bloop, bloop.
I'm sure that happened with some witness.
Forward?
Yeah,
But I'm not 100% sure.
right after this.
I don't think. it
Talked
did.
about how
At
Mr.
least-
Magoo
Anybody?
lightly made a prior inconsistent statement. so
Differently than they had
took that
print,
out.
but something they,
Script and cross-examining today, and that wasn't, he just,
defense wants it out. We agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about?
It's right after this, so we're fine.
So I'm inclined to take it out.
and we have no objection.
All right, that's why it was in italics before.
I'm sorry, everybody. I'm glad.
Your Honor, then the impeachment by defendant's prior bad act.
Here we go.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point.
Of course you do.
It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
They're letting it in. They need to know he pled guilty
It's
to
an
it.
interesting question.
This is
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring?
right to
Can
your-
you have a prior bad act that's
right to
part
your
and
question.
parcel? Is it prior to this time? Is it prior to the crime that was charged?
See,
It's arguably subsequent, Your Honor, but,
Right.
I mean, it's arguably,
What about the lying to his federal probation officer?
that would appear to be a bad act, arguably a subsequent bad act, but,
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the
better be
Massachusetts
researching that.
Jury Trial Bench book. And I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and
So-
subsequent bad acts, that he's not charged with those, and that they have to, just like the
Like I
model
said.
instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if
Pause
they
it a sec.
believe that the body was disposed of in bags.
Let me
Anybody's
let me
gonna
let
think
him
that's a
finish this
bad act.
argument.
And they need to be instructed that they can't, he was not charged with anything, and therefore they
What?
can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse. an
So I'm
instruction.
looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes, we
Attorney
are,
Tipton?
we are.
But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Ana Walshe,
Well,
and the lying to the probate? So that's not what's in
Hear
here,
him?
but are you saying, do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
or pause it.
But
You,
I gotta take this guy out. Did you hear that?
Yeah. Was he yawning or whining or what was it?
It was like a plaintive wail.
Yeah.
I've never heard him do that.
No, me neither.
I gotta take him for a walk. I'm telling you,
Well,
this guy's got to go out.
okay. So I'm just saying that with this instruction, that the defense should be arguing at least, Your Honor, I understand you don't want to get that he pled guilty in, but I think the jury needs to be told that prior to this trial, the charges of illegal disposal of a body and lying to the police were addressed and resolved outside of this trial. He should be making some kind of arguments about this, because if her issue is like, I don't want them to know he pled guilty, you can't have evidence of prior bad acts without telling them that he's pled guilty to it, or that he was charged with 3 charges related to the matter that brings us here today. This, and that. These two were addressed and resolved before coming to trial. That's it. Just say that. And he should be asking for that, in my opinion.
I agree.
Because the jury will be confused by this. And
I
you
thought
can't-
he kind of tiptoed around it a little bit there, a little bit. Because, I mean, if those charges don't exist, then there's an argument to be made at, like, because he said the words, he hasn't been charged with that crime,
Right.
like acting as if he hadn't been, which he
Right.
was.
Right.
So because it's like, is that part and parcel? Like the murder is the murder. So whatever
The
he did
defense
with
wants
the
to
body
argue it's
after the
not part
fact-
and parcel. The defense wants to argue, should be arguing, in my opinion,
Yes,
they
I
are
agree.
prior acts, which is why the jury needs to know he was charged and convicted. You can just say convicted of them, however you want to say it. Or like I said, if you really want to avoid everything, just that he was charged with these 3 offenses and the 2 have been addressed before you're here today. So you don't need to concern yourselves with them, but you can consider it as a prior bad act. Something like that.
prior or subsequent bad act. See, they
So I
add
looked
that
at- I looked at the thing, and this
they
is
add
just
that
a
language.
quick Google search of it. Is a prior bad act prior to the crime charge or prior to the time of trial? And, the AI overview says a prior bad act can be from before. I mean, I should put this in my, I just didn't feel like opening up my Westlaw, so I just did this real quick. It can be before the crime charge or even after the crime, but before the trial.
Hmm.
And I'm going to Westlaw it as well. It's
That's
just not an
interesting.
issue that comes up that much, so I can
Right.
understand
I mean,
why they're
I
discussing
don't
it.
remember ever having this, because it's rare most of the times, unless there's, a period of time during an investigation in which the perpetrator's out and about still doing bad shit. Most of the times if they catch somebody, quickly after the crime, and they're in custody, they're clearly not doing anything unless it's something that happens in the jail while they're being detained. It's a pretrial detainee. All right. Yeah, I mean, Kurt, but they abandoned it. What do you mean I mean, like the concept of it? Yeah, because they rested without putting on a case. So, and then she ruled in what my estimation is against them in terms of them being allowed to get in, have the jury find out that he pled out to the lying to the cops and the illegal disposal of the body, which I think is a death knell to them, to the defense. I don't know, man. Like Allie was saying, that was something that he should have known. Tipton should have known in stone prior to making any decisions. And I'm talking about his opening, when he basically told the jury that Walshe would be testifying. I don't know.
Do you want that to be included? So in the proposed instruction, and so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Shipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
Yes, Your Honor. I was anticipating there to be a proposed other instruction like you had, but yes, I
Okay.
would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder.
Wow.
Uh,
That's just not true.
Not true. This trial is only, they need, this is, okay, this is a very unusual circumstance. It does not come up much where the defendant has pled guilty on a multiple count indictment or multiple, count
I'm just
trial.
pausing there because if I
Some of
move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
Yes.
Love that. Thank you. Thank you for spreading the
Let
word.
me take a minute.
All right, so here's a.
All right, so if I say something along the lines of, the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely,
Unbelievable.
and I wrote
the defense is an
a few things in there,
I'm shocked.
and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right?
So
Lying
those
to
get
the
in because
police
so they get
and
in
or
if the-
disposing of the body of Ana Walshe and or lying to his federal probation officer. So all four things would go into that parenthetical. Okay, and then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right, what do you think about that, Kamala?
Will the court be removing but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud and that he was charged with in 2018 and sentenced in 2024,
Right, pause it, babe.
semicolon, lying to the
Hey,
police,
I want to hear it.
semicolon, and or disposing of the body of Ana Walshe, semicolon, and or lying to his federal probation officer, end parenthesis.
Well, that's a huge that changes everything. So now she's adding that to the instruction?
Yeah.
Wait, so has she reversed her ruling?
No. Here, wait. Let me take over the stream because I'm at the same spot.
Okay.
And then
All right, I'm going to take him. I'm going to be listening though.
wait. Okay. Get off that thing. Okay. So make sure I have everything. All right. So I'll just go.
2024, semicolon, lying to the police, semicolon, and or disposing of the body of Ana Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
Well, I have to say, I'm shocked that the defense is not pushing more.
So you're not,
Then I go back, I don't think that's appropriate to add the for one thing.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to,
Tell the jury that he was convicted.
I don't know what I
of the
do
other.
about the other things. Because you can see the issue that raises.
All right, now I need
Your
to
Honor,
know.
there's also,
All right, now we need to read the prior Brad Act so we know what the hell they're not telling us. Massachusetts prior bad act. And this might be it here. Oh no, this isn't a jury instruction. This is just the rule. Model jury instruction. Let's see. All right, I think I got it. Okay, so I'll just read it. You may consider testimony, blah, blah, blah. You may consider the evidence for specifically, you may not use it. Okay. And then where are these two more sentences? All right, so let's read back what she said because what I'm pulling up doesn't say what, I don't know what these other two sentences are, but.
Are contained.
I don't find it fair it would be extremely unfair, semicolon, charged within 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Ana Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
All right, so here's what I think, guys, because I'm looking at a model instruction that is as of February of 2024. It doesn't have the that exact language that I just heard. The defendant is not charged with committing crime other than those alleged. You may not take the testimony as proof that they committed the crime charged. You may not take that testimony as proof that the defendant committed the crimes charged, nor may you consider it as proof that the defendant has a bad character or propensity to commit crimes. And it goes on to say, like, you can only consider it for this. And then there's these last two sentences after, you may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed the other acts, they must also have committed the offense alleged. So that she must be talking about language like that because they're using it here as evidence of consciousness of guilt evidence. They are the state just argued it's part and parcel of the crime. All of this is because they are avoiding telling the jury that he was charged with, and however they want to word it, convicted, found guilty, pled guilty, resolved it, whatever, these other offenses. It's creating a huge appellate issue here. And that could be something that plays into what the defense has decided to do here by not putting on a defense. They may have decided that this appellate issue is so strong that they're going to win. I mean, I don't know that to be the case, but all right, so let's hear what she says.
So you're not,
Then I go back. I don't think that's appropriate to add the "for one thing."
And that I don't see that
The,
in the model
last two
instruction for
sentences.
one thing.
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things. Because you can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Ana Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Oh.
I cannot find a model instruction that has the words "for one thing." If that was
Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the
All right, I
consciousness
found
of guilt
something.
instruction, somewhere in that vicinity. And if you have any,
Here's what we got. All right. Okay, here it is. Limiting instruction. All right, they're talking about the judge in this case, the defendant, clear, forceful, limiting. The judge instructed the jury to consider the prior bad act testimony only as evidence of the nature and relationship between the parties of the defendant's motives, state of mind, and intent. So that's sort of what we're talking about here. And not as, quote, proof that the defendant has a criminal propensity or of bad character. The judge continued her instruction as followed. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed those acts, then he must have committed the offense for which he is charged. It would be extremely unfair to consider this evidence for those purposes. For one thing, he is not charged with anything related to those acts, and those acts have no relevance whatsoever in the case charged. So that's the language that obviously they're talking about. She's like, well, we can't not, have that here because it makes no sense. And I don't know, like Bob said, maybe this is only interesting to like me and other lawyers, and you guys are like, can you please stop? Because I don't care about what you're saying right now. Like, I just do not care. So let's just continue.
strong preferences, you let me know when we get down to page 27. Recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. To be continued on tomorrow if we need to discuss it more.
And I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on that page? Let us see. Okay, that's COG. Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Ana Walshe's body. I would just suggest that that should be tried to conceal the disposal of Ana Walshe's body. And in the
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All
accurate.
right, so what do you want me to subtract?
Rather than saying taken steps to conceal the disposal of Ana Walshe's body, it's tried to conceal Ana Walshe's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
No, bullshit. The defense definitely wants it to be the other way around. See, this is why all of this is wrong.
So you want me to taken steps to conceal Ana Walshe's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the
disposal
body,
of it.
not the
Yes.
disposal of the body.
Yes,
No.
Your Honor.
All right, that's
Conceal the
probably more
disposal of the
accurate.
body. Why isn't the defense
So
chiming
under
in?
the Commonwealth's request, I would delete the 3 words, the disposal of.
No, but that's what
Will you add the word tried?
tried.
What do you want me to add?
Tried. I thought I heard the Commonwealth asking for tried.
But he did. Nobody found the body.
Commonwealth's content with how the court articulated the
Well, attempted to take steps
Yeah, I can
might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about
Why aren't
tried,
you
not
insist-
waiving any argument to the conscience.
All right, I'm going to leave it.
Right, so the language before was very much better. Was better for the defense. It said that he took steps to try and conceal the disposal of her body. That's what the defense would want, right? That he was hiding the fact that he was disposing the body, not that he was just hiding the body. He was concealing the fact that he was disposing the body. And that is the point. That is the entire point here. What is this evidence? What is this consciousness of guilt of? Is he trying to conceal the body and the murder? Or is he trying to conceal his illegal disposal of a body? He's trying for them to not find out that he is illegally disposed of a body. This is huge. This is it is Pokemon says a circular argument. In a sense it is, and in a sense it's not. Because consciousness of guilt, the defense should be allowed to argue that this is consciousness of guilt of disposal of the body, or is it consciousness of guilt of murder? And the judge is telling them you can consider this as consciousness of guilt for the murder, but since the disposal of the body is not in play here, they don't hear or consciousness of guilt of the hiding of the fact that he was illegally disposing of a body. So the defense should be using this opportunity to every time on the record bring this back to the fact that this jury needs to know he pled guilty to disposing of the body, that this consciousness of guilt evidence speaks to both. Was it consciousness of guilt of I'm hiding the fact that I disposed of a body by disposing of it really well, or am I hiding the fact that I killed a body by disposing it really well? And is that making sense to you guys, this distinction that I'm making? Man, I wish Bob was here for all of this, because this is to me, very interesting legal analysis. Like, I'm not seeing why the defense isn't focusing on this more and keep bringing it back to the fact that the jury somehow needs to be told of these things. All right, let's go.
Like it is.
I'm going to go back.
What the evidence shows. I'm just talking about tried, not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of.
She's taking it out.
I don't like the tried part.
And she doesn't like the
In
trial.
the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
Wow. I'm sorry, I'm just not going to get over it. I've been.
And there, I got the language right. In the second attempt, in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while.
Well, Judge,
All right.
no one thinks of
Any
you like that. We all love
Other edits to that consciousness of guilt instruction. Recognizing the defendant doesn't want it.
Right.
And that objection is noted and lodged.
Right. I was just going to say, it's very, very important for appeal that every time you say anything about modifying an instruction you object to, that we object to all, like, over and over again, because as soon as you modify an instruction, the appellate court says, well, you waived that objection because you assisted in modifying it. So it's very important that she's putting that on the record and that he's putting that on the record. I've seen it before. It's definitely a thing. Defense, come on, make the argument.
I think she's done.
So, once again, I refer to our prior pleading.
Okay, this must be about.
And on page 4.
Yes.
I'm asking that be included. And I modeled that.
That be included. Thanks.
Trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intended,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instructions, because I think just the title alone.
I think the lawyer is trying. So uncivil law says, and hi, by the way, I don't know that his lawyers hate him. I'm assuming responding to someone else's comment. Lawyers can only do so much. We have to play the hand that we are dealt with. Sometimes you don't leave us a lot of great cards to play. I think that Tipton is trying the best he can, and he is fighting hard for his client. I just think he is neglecting arguments that he could be making. Now, I don't know if, like, what he's referring to, this pleading he's referring to, maybe it makes this relates back to or somehow incorporates an argument about the fact that the jury needs to be advised that he was charged with this, and what, like I keep saying, whether it's he pled guilty or however they want to put it. But either way, I just think he could be doing more along these lines, but I don't think he's intentionally not doing it. I just think your mind is focused on 1,000 different things at trial, and I just think he's missing an argument that he could be making here. And I can tell you, I think that this judge could be swayed. If you keep bringing up an argument and relating it to how it applies to each and every instruction we are talking about here, she might say, all right, I'm starting to see why this is an issue, and we might need to reconsider what we tell the jury about this. If they made a strong enough argument, if they tethered it back firmly enough, she's swayable. She's reasonable. She is not dead set and not open-minded. This is not that judge. And I just think he's missing an opportunity in that regard. If you could try not to be horrible monster, that would help us a lot. Right. That'd be better if our defendants could try not to be that. So.
Draws attention to the jury where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in my opinion, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after. Because
I guess I'm just pressing this.
All of this screams to how the defense fucked up the opening in this case. In light of what has happened, the defense fucked the opening. Instead of like just going on and on about how the evidence is not going to show you how Ana Walshe died. The evidence is just going to show you that Brian Walshe disposed of the body. The evidence is like, that should have been the theme. And I said it over and over again with all of the cross-examination questions. You don't have to say he pled guilty to this to ask the question of all of these things are consistent with acts taken to dispose of the body. Correct? Correct. You can't tell from the DNA, from the blood, from the dumpsters, from all of the things, how Ana came to die, what the intent was that brought about that death. I'm not like saying exact questions here, and it's killing me, you guys. It's just killing me. I mean, look, I want him to go down. I think that he committed this crime. Okay. Whether it was, something that just happened second degree, or first degree, I don't know. But I can't turn off my defense mind. So I'm just focusing on the things that the defense counsel is doing wrong, and ways that they could be doing things differently. But, I don't know. I mean, but then again, is it possible that it was accidental and then he disposed of the body? I don't believe so. You know why? Because he's looking to get a haircut. He's looking to get a haircut. That happens. You accidentally unalive your wife and have to dismember her, slice her up and disperse her about the city. You are not getting a haircut. So to me, it speaks to at least second degree. you know? Like, I can't believe it was an accident, because you would have had a much more despondent person at the end of it. And again, I don't believe this sudden death thing because of the lack of searches. That begins and ends for me right there. He didn't search anything about why is my wife all of a sudden dead, you know? So I just don't want you to take my like high focus and irritation and inability to move on from the things that the defense is not doing to think that I'm like, I want this guy to skate, you know? And what my personal opinion is and what legal standards have been met are two completely different things. So looping back 1, 2.
As you were arguing, I'm like, that's not going before, it should go after. Because
And I guess I'm just pressing this supplement. It's primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right?
Okay.
And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may.
Or not.
She's like,
having said that, I guess I'm just.
Hey, don't take my instruction. Don't take my advice here, counsel. But, you know, it is actually always helpful to use, and the prosecution always does it, but to use the jury instructions that are helpful to you and highlight them and show them and talk about them. But he's like, I might not, Your Honor. You know, who knows?
Argument, including this one. But anyway.
I may, but.
Or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017.
I've upped it to 1.25. If it's driving a lot of you crazy, just let me know. I'll bump it back down.
Not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. I sort of running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome. So I've now changed it to I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing that I can give them. So if that answers your question, that's how we'll do it. Now you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23.
Well, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times.
So I read that to you guys earlier.
I think this is with a more modern version of that. But if you want to propose some language, I'm not adverse to explaining.
I'm just objecting to any additional language, and I'll wait and see what they propose.
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like
They will.
I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving you that heads up. I don't want to send you something and you would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend.
Right. That
I mean,
resolves everything.
not this weekend. It feels like this weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want.
Makes the most sense to me. I'm not sure what both attorneys are thinking here. There's that you can't make inference upon inference upon inference.
All right.
Language that they
Anything
use
else on the instructions?
Not from the Commonwealth.
All right. What about lesser included? Let's get to it.
I really didn't mean to set off a,
Oh, maybe
there's a
not.
word that comes to mind, but it wouldn't be judicial, so I won't use it.
A kerfuckle?
When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago.
Oh, but
And I'm going to tell you what
not writing checks.
the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yeah. Writing checks.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing
That's
is.
what they're talking about.
And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this weekend. I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197.
Somebody write this down.
And that cites to Commonwealth versus Nelson,
6.
468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper.
Right. But
It seems to me that they could point out that there's no evidence that Ana died of any natural causes.
there's no evidence that
I read the pleadings that just came through. And if that is where the line is drawn, you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure or the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I'm drawing the line, take a look at those cases, and we'll discuss it again before before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
That there is no evidence that Ana Walshe died of natural causes.
and of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
and I'm responding to something that the Commonwealth represented. I'm not going to go into right now. So let's just stick to this if we may. So if the government's allowed to say what
I just said.
I get to point out
of
the
course, the
ME.
defendant can argue there's no evidence that there was any homicide or any.
I expect you're going to.
I shouldn't be here, I suppose. But I can once again recite the evidence of substance like the death of human evidence.
Right. Yeah.
That's a little complicated because there's absolutely none of that ties it to Ana Walshe. There's no testimony before this jury that ties sudden, unexpected death to Ana Walshe, is there?
Yes.
Judge, when the court asked me that, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walshe. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? I shouldn't use the word speculate. Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't.
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can.
Why can't they defend?
Their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to another.
So I think when the judge says there's no evidence that there was a sudden unexplained death of Ana is because he didn't get on the stand and say exactly what he said in opening. The defense counsel said in opening that she was fine 1 minute. He left the bed. She came back and she was suddenly and unexpectedly dead. The evidence they got in is that people can suddenly and unexpectedly die despite being healthy. So this is exactly what Bob and I were arguing earlier, where Bob says, she's going to limit him some. She's going to limit him some. And I'm like, I think she's got to let him, draw reasonable inferences. And we were at that point talking more about that the evidence demonstrates disposal. But now it sounds like the judge is going to limit the defense from arguing that she could have suddenly and unexpectedly died. And I think there was enough evidence with just evidence that somebody can suddenly and unexpectedly die, even if they're healthy, even if they're this, even if they're that, should be enough for the defense to be able to argue that the evidence she very well may have suddenly and unexpectedly died. But the judge seems to be putting some parameters on this. This is going to be a huge blow to the defense if she limits them in this regard.
Me from the searches to
Let me go back a little bit more.
the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean for.
So have you been listening?
Oh yeah.
So-
Oh, by the way, you're fucking awesome at YouTube. Like seriously. Like I loved listening to you.
Aw, you're so
I really
sweet.
did. You're really fucking awesome.
Did you
the
hear
only
this
thing that-
last part?
No,
about-
that was the only part because we got a call in from the service, which I want you to answer when we're done. To call this person back. But the only thing I caught the beginning of it. I didn't catch the last 60 seconds.
He's wanting to argue that there's evidence that he wants to argue to the jury that the evidence equally demonstrates that she suddenly and unexpectedly died. And the judge said, but there is no evidence of that as to Ana Walshe. And he's like, what? And so that's where we're at right
I
now.
mean, that's what I was telling you.
I know.
Like, but like there was one thing that I wanted to give a devil's advocate position on, and it was with the haircut. When you were talking about the haircut,
right?
The only devil's advocacy position that I can think of as to that haircut is that we know in terms of his probation, his
It
federal
was January
probation
2nd.
officer.
He sent the request, I think, January 2nd for a January 11th haircut.
I thought that there was a schedule in place for grooming, like every month. That's what I thought. Because my thing is like, okay, well, if it's standard fare for him, like if he does it like clockwork and he's trying to be like, I mean, obviously the pushback is like, dude, your fucking wife is missing. Who gives a fuck about a haircut? But like from his mind, his warped mind, he's thinking, all right, well, if I don't do something that I've been doing every month that I've been on probation, are they going to think that there's something weird? But you know what I mean? I was like
my wife is missing.
Right. I mean, that's always going to be the pushback, right?
All right. So let's see what she says, because this could just be the final death knell.
From
I'll go back.
breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the the other distinctions in the evidence.
All of which, Judge, as we've always argued and we will continue to argue, came after.
I love
death.
this judge.
So the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury, and it's up for the jury to decide if they can. What evidence do they have as the manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified, and it's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not a homicide?
But there's evidence in the record before this jury that
I don't want to interrupt the thought process, but
Is she frozen or
there's no objection.
She's thinking, which I love.
To the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later. So we made it.
so you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
Yeah, I agree, they will.
So, for example, the slipper, the blood in the hair.
The slipper.
I presume their argument is going to be that that happened before.
Yeah.
That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
Right, because if you suddenly and unexpectedly die, you're not bleeding on your slippers.
Wait, what is she talking about? The foot covers?
The slippers. And the foot covers are the Tyveks he went out when he was dismembering. He got little footies. Got a whole
She
body
made it
suit.
sound like Those were purchased before.
No. She's saying the
Bloop it back.
slippers, the bedroom slippers.
I heard that.
Right.
Like
right
the
on.
last thing she said, just bloop it back because I got a little lost right there.
Hair.
I agree, they will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
All right. This is off.
That's where I got confused.
Yeah, and it's distracting me because it's like off, like her mouth and her movements are not. I'm gonna refresh.
Synced up.
We're at 12:02:09. I'm gonna go back to it. Gotta go based on
What
the
they
time.
consider to be bad, and I
All right,
frame
wait.
our
We're
instruction
not
as
anywhere
prior
near
and subsequent bad acts.
12:02:09.
That he's
Hold
not
on.
charged with those, and that they
What are we
And
at
there I
here?
got the language right
Not yet.
in the second attempt, in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while.
Whoa, you went way
Jury that
back.
I
ties
know.
Sudden,
Oh.
unexpected death to Ana Walshe, is there?
It's lined up
Yes,
now.
they
Yeah.
can.
We're not there yet.
Why don't they have
I was
12:02.
sitting there thinking while she was
For example-
going through that, answering their question so thoughtfully as to why she won't be supplying the jury with instructions in the box when she's charging them. And I'm like, what a fucking amazing judge. Like she's not a fucking pompous asshole up there. She's self-deprecating and most importantly, she's thoughtful. Like she thinks about little things like, I want them engaged in what I'm saying to them. I want them only taking what I'm saying to them orally. I make mistakes. I've never in my entire career on the bench and since 2017 put out clean instructions. There's always a fucking error. Maybe this will be the time that I love everything about her. Like this is what you'd be on the bench. Like,
Thanks, babe. So Iceman makes a point that we've
I've
talked about.
I've been telling Allie to get on the bench for 10 years.
And I've been hoping we move. So Iceman says, question, couldn't one of the defense arguments for sudden and natural causes be with the COVID vaccine card and Legionnaire's disease that was brought out in the Commonwealth's case? It might have been able to, but that I did not hear him ask in his litany of things that could cause sudden unexplained death. There have been sudden unexplained deaths with the COVID vaccination. He didn't ask that question. And he didn't ask it with Legionnaire's disease. I brought that up yesterday as whether that was a possibility. But my understanding is you'd have some symptoms with Legionnaire's disease because first you'd start like with a cough and a cold or something. But
right. There's going to be some symptoms that
we actually had a friend who went from healthy, but I do think she was telling me that she had a cold to on her deathbed with Legionnaire's disease for months.
Yeah.
So, but the answer to your question is, I think he could have, but he didn't because he went through various reasons for, sudden unexpected death with their ME and did not discuss either of those two things. So now I think he could not do it.
It's facts, not in evidence.
Right. There is a card, but I still don't think he could argue that the jury on its own should decide that someone can suddenly and unexpectedly die from a COVID vaccination.
Well,
there was no evidence.
It wasn't raised by anybody. He didn't put it
Right.
in he didn't ask the question of their witnesses, and obviously they didn't put anything on in their case.
Right.
So
all right. So we are about 30 seconds from where we were before. Here we go.
The slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. And that's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made.
I think she meant that the other stuff was evidence of what happened before because the slippers were purchased to be used. I think it was just that
Oh,
she,
the footies. The foot
yeah, I think
covers.
she was kind of relating back to the slippers and the hair when she used before again there. I think
Yeah.
looping back.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence
Pause
that
it
Ana
one
Walshe
sec.
died of,
Sudden unexpected death.
The friend, the last
it's-
witness did testify that she was tired or
Right,
she was
but-
exhausted.
But to Love Always Truth's point, she was very clear of tying that back to like emotionally drained and the back and the forth and the like she was.
Plus, they followed up with the question about the karaoke and dancing that she went out to that night.
Right.
So,
And that she told her husband she loved him less.
do you love me? Not so much.
A little less now.
some natural causes. I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, then the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language and consciousness of guilt, a person is acting in a way not out of consciousness of guilt, but out of fear or fright or anything of the sort. So why is it that given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Ana Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the consciousness of guilt. And so the jury gets to decide. And certainly, the thrust of that argument is that it raises a reasonable doubt. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right.
Well, but this has expanded beyond that.
Thinking we might find common ground here.
Sounds like we have. Sounds like we have.
So as long as we're able to argue that a possible manner of death is sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide,
Nonsense.
Have we found common ground?
I think we have.
I think we're close.
True.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
He fucking avoided a bullet like a mofo right there. She almost was like, nah, you can't make the argument about sudden unexpected death. So Iceman followed up with, Allie, they brought up in the Commonwealth case, and could he use it in his closing argument? I get Tipton didn't present it, but he did ask witnesses about Legionnaire's disease. So you're absolutely right. It doesn't have to be presented by a witness called by the defense. What he didn't do, what Tipton didn't do, is ask the ME if Legionnaire's disease someone can suddenly and unexpectedly die by being exposed to Legionnaire's disease. And that's something the jury cannot just infer on its own. Same with the COVID card. He did not ask, have people suddenly and had a sudden unexplained death after getting a COVID vaccination. If he had asked that of the ME, then sure, he could argue it, but he didn't. So in my opinion, he wouldn't be able, that's not a reasonable inference that the jury can make, that someone can suddenly and unexplainedly die from a COVID vaccination without any evidence to suggest it, or Legionnaire's disease without any evidence. Even if the medical examiner said, well, I mean, it's possible, but highly unlikely, then he could argue it. But he didn't go there. He didn't take that extra step. But I, appreciate and agree with everything you're saying, Iceman. And, Bob was thinking COVID from the jump, and I looked into Legionnaires as well, but it wasn't asked in the sense of connecting it to sudden unexplained death.
Well, it's like you were begging them to do, like you were talking about 20 minutes ago, like the question, like he never asked that goddamn question,
No.
like the most important question that would have given him so much leeway in closing to argue, and he just never asked it. I'll never know why he didn't ask that question and it was there 10 different times he could have asked it.
Right. Without mentioning pleading guilty, not pleading guilty, charge,
Right.
no charge,
Nothing to do with it.
Right. Right. All right. Where am I? Okay.
There's always surprises.
That's true.
Wait, let's see.
All right.
What's
And again, to one another,
Thank you, Your Honor.
so that there's no surprises.
There's always surprises.
there's always
That's true.
surprises. That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just
She
think
wanted
that
to say shitstorm.
the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now. All right. Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it.
Tell us
How long are
what
the
it
parties
says.
thinking they're going to need for closing arguments?
Damn it. What? No discussion of lesser included.
That sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off in
Wow,
other
what a
cases when it's a
reasonable-
2-day case and we're on
reasonable
45,
judge.
47, but that isn't this case. And,
Wow.
but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good, as opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed, and I will then create a new draft, and that will go out to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow, so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it.
Man, I cannot
All right.
believe they're not bringing up lesser
Thank you.
included.
But one other thing that I want to
Unbelievable.
say is that, you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides and working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case. Thank you.
Wow. She was sticking up for the Commonwealth right there. Like, don't let that Karen Reed bullshit taint your opinion of our judicial system here. I mean, that was a statement there. I can't believe they didn't bring up the lesser included. I just can't believe it. Mal, so my thought on that is that my feeling yesterday when the Commonwealth rested was that my initial instinct, the first thing that I'm like, wow, I don't think they've met their burden as to intent / malice aforethought. And I don't think that they've met their burden as to premeditated at all.
I think it's possible that the second degree is like incorporated into the first degree because their model instruction says if it's not first degree, it's second degree.
Is that what it says? 'Cause
Yeah.
So when you had pulled up the statute, so yeah, that's good to know. As long as it's incorporated into it, then and obviously that's not something that they need to really discuss if it is incorporated into it. But to Mal's point, like I felt that way, that they didn't meet their burden. So then it becomes an evaluation between defense counsel as to whether or not, if we think they haven't met their, and it's a massive calculated risk. It just is to not put on a defense. You know, it makes you feel very, very uncomfortable as a defense attorney because you're allowing the state to go in there, tell their tale unchecked. You know, so it's a really, really hard thing to do. And ultimately, and again, the only thing that Walshe had any kind of control over, and it was completely in his control, was whether or not he was going to testify. In terms of the strategy that was going to be employed, had the defense put a case on, that was entirely within the purview of the defense attorneys and not Brian Walshe. So if Walshe would have said, look, man, I got to get up there, I got to testify, we're not having this conversation about them, you know, resting without putting anything on, because they would have at the very least had to put Walshe on. And if you're putting Walshe on, I think that probably is going to force your hand in terms of putting some more witnesses on, maybe. But, you know, I mean, like once they've reached the conclusion that the state has not met their burden, I think it then becomes an evaluation. Is it a situation where if we put on a defense, doth the lady protest too much and we don't need to do anything? Like we don't want to cloud the fact that they haven't proven their case by coming in and putting on a bunch of shit that could murky it up for them, you know? So I mean, it's a strategy.
Right.
And I think that at the end of the day, Tipton, like Ali said, got some breaks. You know, that check writing thing was huge for him. Like not like kind of cutting and hearing the Commonwealth say, we are not going to flamethrow him for him writing checks, you know, or writing checks that his ass didn't cash during trial, and her flat out saying, we're not going to bring it up. You know, he avoided, you know, I mean, but even if she's not saying it, the jury very well is thinking it.
All right. So here is the murder in the first degree jury instruction for Massachusetts. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. And then it says, list the theories as follows: murder with deliberate premeditation, murder with extreme atrocity or cruelty, or murder in the commission or attempted commission of a felony punishable by a maximum sentence of life. To find the defendant guilty on this theory, any of these theories of murder, you must be unanimous. That is, all deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory on which you unanimously agree. If you are unable to unanimously agree that the Commonwealth has met its burden beyond a reasonable doubt, any of the theories has met its burden to prove beyond a reasonable doubt any of the theories of first degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. And then this is what I'm wondering about. Where are these lesser includeds? You know, is the defense asking for these?
I don't know.
Automatic. These are where the jury are to be instructed on voluntary or involuntary. So if that's happening, it says if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt the defendant is guilty of murder in the first degree or murder in the second degree, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser offenses of voluntary manslaughter or involuntary manslaughter. That's what I was going to ask you. Like, where is that request? And then I'll begin instructing you on each element. So, first murder in the first degree. So we'll read the premeditation one because I think this is where they're going. I will first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. The defendant caused the death of Ana Walshe. The defendant intended to kill Ana Walshe. That is, the defendant consciously and purposely intended to cause Ana Walshe's death. The defendant committed the death with deliberate premeditation. That is, he decided to kill after a period of reflection. This is not going to come in where there's evidence of self-defense or defense of others. No, where there's evidence of mitigating circumstances. If this were relevant, it would say, in addition to these elements, the Commonwealth must also prove there were no mitigating circumstances. I don't think it was. It is. Now, a defendant's act is the cause of death, and the natural, unconscious, and continuous sequence resulted in her death. So the second element is that the defendant intended to kill Ana Walshe. That is, the defendant consciously and purposefully intended to cause Ana Walshe's death. Now, where there is evidence of accident, there isn't here, right? So this is not coming into play here. But if there was, if you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by negligence, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find the Commonwealth has proved this element of intent to kill the victim. So, I mean, if he's coming up with lies, that would have been a better lie, that there was an accident, and then he didn't think that they were going to believe him, so he disposed of the body. Why he came up with this, she was just suddenly and unexplainably dead. I mean, would we all agree that that is a strange thing to say, instead of there was some accident that resulted in blood and resulted, that he thought they're never going to believe it was an accident.
Yeah, like she slipped coming out of the shower.
Right.
Cracked her fucking head open.
Or I ripped the towel out of her hand, and she fell backwards or whatever,
I mean, the slippers could have been in the bathroom, not on her feet necessarily. And she, slips, cracks her head open, blood gets on the slip. You know what I mean? They don't necessarily have to be on her feet in order for them to have the blood on them.
I mean, if you're coming up with lies, there's better lies to come up with than this sudden, unexplainable death situation.
And frankly, it's a way better lie, because that is a situation wherein I think that it might be reasonable for one to think, oh shit, they're going to blame this on me.
Right. And
no one's going to believe that she accidentally slipped and hit her head on the fucking sink basin. No one.
Right. And that you're not searching, why did my wife just die in her sleep? Where there's evidence of transferred intent. If the defendant intends to kill a person, that would be if you accidentally kill somebody else when you're trying to kill.
Didn't they have her slippers as well, or was it only his slippers?
No, her slippers. Hers were the fuzzy ones.
Okay.
So the third element is that the defendant committed the killing with the deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. This is, I would have this up in my defense. Judge is going to tell you about this. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. I'd have that part of this instruction up and being read. There's no evidence of impairment or alcohol or drugs, because in this case, they said even though they were drinking a little bit, nobody was, highly intoxicated. Right. So we don't need to go that. No self-defense isn't an issue. No mitigating circumstances. Not every circumstance you may think to be mitigating is recognized as mitigating under the law. In this case, mitigating circumstances you must consider are the heat of passion on a reasonable provocation, like walking in on your spouse having sex with another. Heat of passion induced by sudden combat. So I guess, I don't know, somebody attacks you suddenly. And excessive force in self-defense or in defense of another, none of which is,
That we know of.
right. And then I'm going to skip the murder with extreme atrocity or cruelty because, I mean, they probably could have tried to argue that with all that stuff, but I think it's clear that that was dismembering. So that would be even harder. No felony in the first. That's not an issue. Let's get to second degree. No impairment. Oh, no, they don't even have. See, so in this first degree murder where it says, I'm going to instruct you after that on second, it's not actually here. So, but we can go to second.
That's strange that they don't have the elements of second.
Well, I guess it's in a, where's the next one? Yeah. Huh. Murder in the first degree. How do we get over? All right, we'll just go like this. Murder in the second. In order to prove murder in the second degree, the Commonwealth must prove the following elements. The defendant caused the death of Ana Walshe. The defendant intended to kill Ana Walshe or intended to cause grievous bodily harm to Ana Walshe or intended to do an act which, in the circumstances known to the defendant, a reasonable person could have known created a plain and strong likelihood that death would occur. Well, I don't know about that.
I don't know
I mean,
about that either.
if they don't get first, then how'd they get second?
I don't know.
I mean, it doesn't have all that other language, so they might be like, all right, well, he did something and intended to kill. He just didn't have time to reflect on it first. And then the question becomes, do they lesser included offenses to murder? Voluntary, yeah, but then they've got it here too, so I don't know.
Wait, that's involuntary. It's voluntary. And then
Well, I would want both. To prove the defendant guilty of murder in the first or second degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduced the defendant's culpability. Okay, so a mitigating circumstance is a circumstance that reduces the seriousness of the offense in the eyes of the law. The killing would otherwise be murder in the first or the second degree is reduced to a lesser included of voluntary manslaughter where the Commonwealth has failed to prove there were no mitigating circumstances. Therefore, if the Commonwealth proves all the required elements of murder but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find the defendant guilty of murder, and you must find the defendant guilty of voluntary manslaughter. So this is not coming into play here because the defense didn't raise any issue of the possibility of mitigating circumstances. So it's not like they just have to prove beyond a reasonable doubt that there wasn't any mitigating circumstance. The defense first has to put up some kind of evidence that could give rise to mitigation.
This would have been like that circumstance. They're in a fight. He pushes her. He doesn't intend on killing her. She falls, hits her head. That's classic voluntary manslaughter.
Right. But involuntary, let's see. Where the Commonwealth has proceeded on a theory of involuntary, no. Where the Commonwealth has proceeded on a theory of as an unlawful, and no.
To me, that's like Like vehicular or
Maybe this
homicide
doesn't.
type shit. Drinking and driving. Get
Yeah.
in an accident.
Well, they did put that word about battering her in the indictment. It's kind of weird. But that would be unintentionally causing a battery. All right, so these aren't really coming into play. So I guess, yeah, you just got first and second. And they're going to argue there's no intent no matter which way. You know,
So Jacqueline had asked, can you guys talk about an appeal when there was no defense? How does that work? I feel like Tipton did this to keep the appeal clean if it comes to that.
I was thinking that and I mentioned this while you were off, babe. If they're confident that there's been a bad ruling or something, they don't want to put on a defense and like muddy it up and be like, oh well, you know, as far as harmless error is concerned, like that more evidence came in, you know, that would have made it harmless. So I think that's a very good point. You can appeal when there is no defense. It doesn't make any bit of difference. You would appeal based on the rulings, you know, that happened in the case or any, you know, issues during the state's case in chief. And I definitely think that might have been a thing that was considered here, is to not give any fodder to it's harmless error, because did you see what happened when he testified? You know?
Yeah, like, and I mean, like an excellent item that could be an issue, it would obviously be her decision not to allow them to charge the jury with the fact that he had pled out prior to trial. You know, I mean,
Right.
they can feel that that's an incredibly strong issue, but I mean, he wouldn't have known that going in.
Or if he
But
did, and he
still,
shouldn't have let him out. If he
I
knew,
mean,
like we discussed it. If it was gray, don't do it. All right. So we discussed earlier that Jaded for Justice became a new member, and then
family hug.
Said, Bob, cannot believe your podcast. Holy shit, it's so good. Had no idea how crazy his story about how they got him was. Way to go. It's a hit for sure.
Thank you.
I have gotten halfway through the episode that was released today. Wait.
Yeah.
Thursday we release?
Yeah, Tuesday, Thursday, Saturday.
Okay. And I forgot about it altogether. What a huge, a huge thing that's just hanging out there that hasn't been addressed by Chicago police. It's a big one. It's a big one. But thanks, Jaded for Justice.
Yes, thank you so much.
Okie Angel says, not going to lie, I'm nervous as hell. Thanks for the pointers. Ice machine. Oh, she's the one getting shoulder. Yeah, they gave me an ice machine. It's like this machine you fill with ice and water, and it's like continuously applying like basically an ice pad that's just continuous at all times. I don't know where you're at, if they're going to give you one of those, but and my doctor just gave it to me. I'm sure it gets billed to me. My friend who's in the neighboring state, he might have gotten his surgery in Illinois. They rented him that very same machine, and that was just the way they did it there. It wasn't like I didn't get asked, do I want to rent or do I want to buy?
Yeah, this is the machine. Looks like this.
You should definitely ask if you're not given one.
With this tube.
Because I don't think my mom was given one. And she just had rotator cuff surgery.
She had a very different experience than you. It's strange.
Yeah. Yeah. But you can look online. They're not cheap if you've got to get it outside of the doctor. But I left with the sling. I think everybody does, and with the ice machine. They already had the pad already on me when I woke up. So yeah, good luck. Our thoughts will be with you.
For sure. John
says no rubber tiles. I forget what that was about. This was at 9:51. So, but thank you for your continued support for 7 months. No rubber tires. What tiles? What are you?
I got nothing.
Sorry, John.
It could have been during like my story time, Bob's story time, when I played that little video.
Oh yeah, it would have been, because 9:51 we were still waiting for them to come back, I think.
Yeah.
Weird Debbie, member for 9 months. Thanks for your continued support. Metal lawn jarts and those
Jarts.
glass clacker thingies. So that's also
Jarts.
must have been something you were talking about. What's that all about? I missed it.
Well, did you see the little thing, the little
No, I had
6-minute
Zoom
thing I
court,
played?
and then I came up there looking for my vape, and I opened the second because I've searched high and wide
Holy shit.
for the one that I opened yesterday.
Holy
We'll
shit.
find it. We'll find it.
Holy shit.
Iceman gifted 5 Defense Diaries memberships. Thank you for your generosity. Gigi says,
Always, Iceman.
GPS a crutch, but it gets me to places safely. That's Bob talking about how he can't get anywhere without his GPS. Hashtag old lady crush. I am a pretty good navigator, though. My twin sister would be lost without me.
Mm-hmm.
We discussed both of Iceman's comments here.
Thank you, Iceman.
Motions and CPA says crazy. Reasonable judges do exist in Massachusetts. Who thought it was possible?
It's not like this is not a Massachusetts thing. I realize that people think that Massachusetts is like the corruption capital. This shit goes on everywhere in this country. There are bad cops, bad prosecutors, bad defense attorneys, bad judges in every single state of the union.
Right. And
This is not a Massachusetts thing.
By Bob and I's response
Alone.
to this judge and what we're saying about her, and we've been in front of many judges, that it's not the norm in every, like Bob's saying, in every state, in every jurisdiction.
Yeah.
You know, like, and we noted here when we know we've got a judge, oh, this judge really considers the law and this judge really thinks things out. I love this judge for that. Like, that's a constant discussion between all
'Cause I'm
lawyers.
going to tell you, and I've said it a million times, Judge Gull in good old Indiana is way fucking worse than Bev Canoni. I'll tell you
Yes.
that. It's not even close.
Richard Allen, guys, if you haven't followed it, you got to look into it. There's tons of coverage on our channel.
Insane
here.
case. It's way more like in terms of the case
Abusive
itself,
judges.
and evidence, and all of the things that came out pre-trial. It's way more interesting than Karen Reed case. I mean, that was, kind of like a typical potential, DUI resulting in death type case, like that are kind of
But for all of the planting of evidence and inverted videos. And
right. All that. I mean, right.
all that
all
stuff.
that shit. But, I don't even know that that's so uncommon.
I mean, it's not as uncommon as we would want it to be. So Iceman came back again. Thank you for your continued generosity. I really appreciate the debate and trying to help me understand the facts and things in this case. You are gifted in the way you discuss these matters, and I really do appreciate it. Oh, thank you.
Yeah, we
Thank
love
you.
We love you, Iceman. Iceman, I got an email. Your shirt should be there any day. Because I finally got an email that it finally went out. So, also Kim, per usual, on a daily basis, once again, sent us $25.
Oh, thank you.
Very simple. She always just says, thank you. Thank you, Kim, for your continued support. We really appreciate that. All right. So, I think
So
what the deal is-
Dom's mom said, posted a 21-month comment yesterday. Oh, happy 21 month. Thank you for your continued support.
Yes.
And we love you too. And we love your continued support. OG Dom's mom.
You are 100% an OG, Dom's mom. We adore you so much. We are so thankful you're part of our community. Thank you for the constant support. It's amazing. Couldn't do it without you guys. You guys are the backbone of this whole little channel. So just know that.
All right. Well, we had a short day.
Short
which is
day.
Great. We
Tomorrow's
might
gonna
be
a short
coming
day.
back today on Aaron
Why?
Spencer.
Oh, yeah. Yeah.
So maybe we take a little break. We
we
set
got to
Aaron
figure out
Spencer
when we're going
live.
to do our Allen primer leading into the appellate brief getting filed. So
What is the day for that?
17th, 12/17.
Oh boy. Okay.
Yep.
It's coming up.
Yep, it's coming. So we'll have to do that maybe early next week.
We got to talk to Mandy about a Bob's birthday banner for
Plus,
tomorrow.
we've got to finish Zach Adams. Like, I'm not leaving that one hanging. Like, I want to finish. We only had about 2 hours. We showed it on lunch, but I didn't get to watch it. I want to watch it. I know DB has been like, he went back and he's watched the entire trial and he says it's an absolute shit show. So I'd kind of actually like to go back and watch the trial. Plus, I think through Trial and Error, their channel, that we're able to, at the very least, hear, maybe see, I'm not sure, the first couple of days of the post-conviction hearing. So, because I am very much getting the vibe that guy's
Thanks,
getting into
Crystal.
trial.
And just so everybody knows, it is 2 days before Bob's birthday.
Oh, so old.
So we'll be
so
celebrating tomorrow, the
old.
day before Bob's birthday day.
Yes.
And yeah,
I'll probably try to dip. Be like, what?
for closing arguments.
Yeah. No, I'm sure I won't. Bailey, were you here when I showed your adorable little pug? I can't remember. I don't know if you were here or if you were already working. If you weren't, I showed that adorable picture that you sent me of your little guy or gal, whatever the case may be. So cute. So cute. All right, you guys, we love you so very much. Please remember to like, share, and subscribe.
Oh, is there something you could forward people to for tonight, or that's too soon?
Yeah, no, I could do it. Just give me a second. Yeah,
Bob is on Publicly Buzzed tonight with Steve. I'm sure it will be interesting and fun. Do you guys have a specific thing you're doing, or
Steve's been kind of digging into watching body worn cam videos of cops pulling people over and shit, which are always awesome, you know, and he's digging for good ones. I don't know if that's what we're gonna do. Like, we didn't have any like specific thing planned. So I think we'll be hanging, having a good time. Shooting the
PB
shit.
is Publicly Buzzed.
So yeah, I'm gonna, if you guys give me a second here, I'm just gonna go ahead right quick and portal everybody.
And then that won't affect, like,
tonight.
if we decide, because I think we are coming back with Aaron Spencer, right?
Yeah, it depends. Like, I think I'm jumping on with Steve. I think it's, let me double check. It's either 7. Hold on, I'll be able to tell you in a second.
Yeah, I'm meaning this afternoon before.
Oh, I got to bring the car to Jim. I have to.
All right, so we're not coming back this afternoon, guys.
I mean, unless you want to go solo.
Nope. Thank you.
Solo. All right. Okay. Okay. Boop, 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 boop. Where's Steve? Where is Steve-O? Did he not create?
6 Eastern time, Pokemon says. So it must be somewhere.
Wait, 6 Eastern? Oh,
It's 5 your time.
I know. All right. I am. Pokey, have you seen, has he set the live? For some reason, I'm not seeing it in my things that I can portal to.
Yeah, I don't see it set yet.
Maybe Steve hasn't set it yet. I don't know. Well, I can't portal to it if it doesn't exist yet. Do you see it on his channel?
No, I'm on his channel, and I clicked on live, and it's not there as upcoming, and I clicked on home, and it's not there. So unless we're
okay, well, I tried.
His looks different than ours looks.
What do you mean? His
like
what?
the way the homepage of his. I don't know. It doesn't matter. All right, everybody. Did you finish the portal? Oh, you can't portal.
Please like, share, and subscribe.
Yes, we're almost at 60. We need you, please.
I know, we're so close. We're excited about we'll have a big 60K party.
But then I'll just be, haggling everyone until we're at 100.
Yeah, I mean, we got to do what we got to do. Got to do what we got to do. And Megan, I'm glad your appointment went well today. Continue the fight. Yeah. And just know we love you guys, because without you, I'm literally just an old man
sitting around talking to his wife.
Boo!